play on the
sorry.
recording.
Good morning. This meeting was properly noticed by having the agendas placed on the board's website on Friday, January 17th, 2014. Everybody should have a green folder. Some people have already done this, I've seen it, but there's a conflict of interest statement there, and give that to Karen. Mr. Royston is absent because he had surgery on a torn rotator cuff, and we wish him a speedy recovery. Mr. Brewer has the flu and also will not be with us, and a speedy recovery for him as well. We'll be taking things a little out of order from the posted agenda. Our first item of business will be a presentation by legal regarding the Open Meetings Act. This was originally scheduled under old business to occur later in the day, but to accommodate the schedules of the participants, Mr. Giannini has agreed to move his presentation till 11:30 after the formal hearing. Just want to remind the board members that you need to speak loudly and clearly and into the microphone. If the red light is not on, then they are not being recorded. So please speak into the mics.
Ultimately, if Bill's not here, but I appreciate Bill and close supervision with this PowerPoint presentation on the
Or could we go ahead and approve the minutes from the last meeting?
Yes, why don't you go ahead and do that, and let me point out that the October minutes have been amended, they've been expanded, so if you take a few minutes to review those on your laptop, on your iPad, they were a little bit different from what was sent to you for approval earlier. We have beefed them up a little bit to include a little bit more about the discussion areas.
Everybody had enough time yet? Henry, Jennifer, y'all okay? Okay, do I have a motion to accept the minutes from the previous two meetings?
I'm sorry, for the November one, it's not noted on here that I recused myself from that hearing. I thought we were just doing October. Sorry, Trey.
That's, yeah.
Mr. Chairman.
Roberts, we will make that amendment.
All right, thanks. As amended, I make a motion to approve the October and November minutes.
Okay, I have a motion. Do I have a second? I have a second. Any discussion? All those in favor signify by saying aye.
Aye.
Okay, minutes are accepted. All right, you're good to go. Thank you.
I have been given a mic. I hope it's picking me up, and if not, I hope that I can just holler at you loud enough that you can hear me. Chairman Watkins and members of the board, thank you for having me this morning. I understand that we're under a little bit of a time crunch this morning, and so I will try to compress the presentation in such a way as to not leave anything substantive out, and we'll hope as well to leave a few minutes for questions at the end. Excuse me. I understand that you have the presentation on your iPads, and it's also behind you if you should have some weird desire to put your heads on a swivel. Yeah, there you go. So we're talking this morning about sunshine laws. We understand that you all have a good deal of familiarity with it. This presentation is part of a series of them that is being given to all of the boards and commissions here in the Division of Regulatory Boards, and the purpose is to just sort of reset our baseline to make sure that we are all on the same page and to clear up any miscommunications or concerns that may have cropped up over the last couple of years. The Sunshine Law really comprises two separate laws, one dealing with open records and the other dealing with public meetings. As a matter of the Open Records Act, excuse me, in the state of Tennessee, I'm honestly going to give very short shrift to that this morning. That is going to cover things like Freedom of Information Act requests, keeping minutes and records of the things that you do. And as far as handling that on a day-to-day basis, that's something that Mr. Crocker and your administrative staff take care of on your behalf, and so is not really the focus of what we're doing here this morning. So what's included in open records as far as the Accountancy Board is concerned? And the answer is everything. I know it's in small type there. The statute says that public record or records or state record or records means all. And we're going to see a lot of this language, all, every, you're darn tootin', you betcha. All documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files, and output, films, sound recordings, and if that doesn't give you an idea of the breadth that the legislature is trying to cover here, they just throw in that blanket, all other material, regardless of physical form, etc. So if it's something that you write down, it's pretty much covered by and subject to the Open Records Act. What is not covered is the devices on which those records are displayed. Okay, so everything on your iPad this morning in terms of content is something that would be covered by the Open Records Act, but not the iPad itself. We'll get into the meat of it, the Public Meetings Act, excuse me, since that's primarily or principally what we're here to discuss today. What then is the Public Meetings Act? It's three main points. We're going to figure out what a meeting is and then what it's not, and try and put some bounds around that so that we know when we're safe and when we might be going too far afield. Once we've discovered what a meeting is, then what does the Public Meetings Act require of you, both in your individual capacity and also as a plenary board? There's a couple of things up there: notice, agenda, public presence, minutes. Minutes, as I mentioned before, is really going to be mostly concerned with the proper recording and archiving of those minutes in case there's a public information request that comes up later. And that's the last thing I'll say about minutes, because that's something, again, that Mr. Crocker and your administrative staff will handle for you. And then the penalty for violating the Public Meetings Act is going to be simply nullity. It is as though it never happened. And this can be a real problem if you say, for example, gosh, there's this thing that we need to do. There is a rule that we really feel it necessary to amend because it's being honored more in the breach, for example, or something of that nature. And one of you undertakes to pick up the telephone and call another of you and say, I'm really concerned about this, and justifiably so. And you undertake then to amend that rule. If it's done off the record or behind closed doors, no matter how good or honorable the action is, it's as though it never happened. The modification or amendment never took place. The old rule would still be considered to have been on the books. And so it can really slow you down. We're going to see this morning that once we deal with meetings...
Could I
yes.
clarify that even if the question is brought before the whole board in a duly constituted meeting and fully deliberated at that time, you're saying because somebody had talked about it ahead of time, that the action taken in a formal meeting is nullified?
That's the razor's edge question, Mr. Blaufus, and my hope is to be able to unpack that for you as we go on. So I see where you're coming from. The short answer for right now, and as I said, we'll get into it in a few more minutes in more detail, is that the nullity of a violative act, generally speaking, will flow downhill, and it can corrupt, I guess the better word is infect, other acts that flow down from that. And that actually is a good segue into here. This is the first part of the statute. General Assembly hereby declares it is the policy of the state that the formation of public policy is going to largely cover your rules and regulations, adoptions, amendments thereto, and then your decisions. Pretty much everything else, including disciplines, issuances, and revocations of licenses, that sort of thing. All of that is public business and shall not be conducted in secret. We're going to find that universally, both the legislature and the courts in Tennessee speak in this very broad, very expansive language. And the one thing that is very clear is that they mean for it to be all-encompassing. The second part of the statute shall not be construed to limit any of your rights and privileges. This article of the Tennessee Constitution is the free speech clause of our state constitution. And what it's saying there is, and the way that the courts have interpreted this intersection between your personal free speech and then what's required of you as a board member, is to say, look, we're not telling you what you can't say with regard to board business. We are telling you that if you choose to say something, it needs to be on the record, with one very limited exception that we'll talk about.
I'm just trying to understand this
Sure.
better. Are you saying that members of the legislature, if they talked about the wine and grocery store bill in the hallway or over lunch, that the action taken by the Senate or the House is nullified because they talked about it informally?
What I am saying, Mr. Blaufus, is that at a minimum, it is open for challenge. At a minimum, it raises a very large red flag. At a minimum, it is the kind of behavior that is liable to get, in your example, those congressmen, well, maybe not sued, but to get that law then challenged in court. Okay. And again, we'll... I appreciate your question, but I really think it's going to work best if we kind of get through this. We're here to talk about what the law requires. That's our job. We're the lawyers, so we're going to try to give you a good idea of the boundaries. But honestly, some of this is a matter of best practices. So, I understand your questions, but let's go ahead.
Well, in other words, you prefer not to have questions.
No, but we're on a tight time schedule. One of my other people here, Mr. Joseph, has an ALJ coming, and I respect the ALJ's time. Thank you. All meetings of any governing body are public meetings and open to the public at all times, except as provided in the Constitution of Tennessee. That's that narrow exception that I talked about a few minutes ago, and it's the executive sessions exception. It's a pretty narrow exception in which you can discuss matters privately, and we'll unpack that executive session part of it in just one or two more slides. It absolutely applies to the accountancy board. You are a governing body. You are, as a governing body, part of a public body. A governing body is the members of any public body which consist of 2 or more members. In other words, anytime 2 or more of you are in the room together and you undertake to discuss board business, that's a meeting and is covered by the Sunshine Law. Excuse me. The last slide talked to you about the idea that your policies, quote unquote, and your decisions are public business. Now it's telling you that your meetings are also public business. Now there's a little bit of a confusion here. We say, well, governing body is 2 or more members of any public body. Well, haven't we just then moved the problem back one step? What then is a public body? The Tennessee Supreme Court tells us that, and I'm not here to throw up law all over you this morning, so I won't be doing a whole lot of citing of cases. Excuse me. But this is one that bears mentioning. The legislature intended, the court says, to include any board, commission, committee, subcommittee, agency, authority, or any other body by whatever name whose origin and authority can be traced to state, city, county legislative action, and whose members have authority to make decisions or recommendations on policy or administration. That is intending then to pick up also your committees and subcommittees. So it's not going to work to say, well, we have to have the final decisions taken by the plenary board in a plenary session, but we can have closed doors for committees and subcommittees. That's not going to work for you. Excuse me. All right. I've tried to lay out then what is a meeting. Let me see if I can put some shape on it and talk about what's not a meeting. A meeting is not any inspection or on-site visit. If a complaint is made, excuse me, to Mr. Crocker and an investigator is sent out, or when you do your annual relicensing and make people come in, if for any reason you send somebody out to visit somebody's shop, that's not going to be a meeting of the board. And we can see that that would get unwieldy if you had to open that to the public every time you wanted to do that. This, I think, Mr. Blaufus, is beginning to strike at the heart of your concern. What's not a meeting? A meeting is not a chance meeting of 2 or more members of a public body. But those chance meetings cannot be used to decide or deliberate public business in circumvention of the spirit of the law. And a brief note about that. If you undertake to send another board member an email or a fax or a text or to pick up the telephone and call them, the courts have been very clear. That's not a chance meeting. One of you did it on purpose. One of you deliberately took an act to contact another person. If you bump into each other in the Kroger or the Harris Teeter, that is a chance meeting. At which point you would talk about your kids, the weather, the potluck at church on Wednesday night, the upcoming golf tournament, but not about board business. There's a case that I've cited there at the bottom. In Aiken, there were some folks who lived on unincorporated county land, and the town of Kingston Springs undertook to annex them. And they made the vote to, the up or down, yes or no vote to do the annexation in public, in a properly noticed plenary session of the town council. But they discussed the precise boundaries of which land they were going to annex behind closed doors. And they got sued over it by those folks that didn't want to be incorporated. And the court said, that doesn't work. That is a substantive violation of the Sunshine Law. Excuse me. Here's an Attorney General's opinion that says that you can share a meal together, 2 or more members, in which public business is conducted, but that discussion shouldn't constitute deliberation. Folks, if you can predict with a high degree of accuracy what some judge after the fact is going to decide, well, was it just discussion or was it deliberations? You're a better person than I am, and but you can see that that's a very fine line, and could be an easy way to get yourself in hot water. What's not a meeting? Again, Mr. Blaufus, this I hope will begin to address some of your concerns. Lunch breaks, restroom breaks, smoke breaks. If you take a recess between morning and afternoon sessions, that may or may not include food. If you have a multi-day meeting and adjourn overnight, those times are not meetings. But because they are not meetings, those are not times when board business ought to be discussed. It's very tempting, I know, to say, well, we're going to take a 5-minute recess and then be powdering your noses in the restroom and say, gosh, based on this evidence I've just heard, I really think X, Y, and Z. That constitutes deliberations and is something that really should be avoided.
I think, just further the point real quick, it is kind of hard to get your mind around, but I would think of it in the way that we've come to accept as a jury. A jury deliberating in a case, they don't get to talk about the case even on a lunch break, so I think that might be a helpful analogy.
I think that's right, particularly in the context of your formal contested case hearings that you're about to have one of. You serve in part as the jury there, as I understand it, and would be forbidden from talking about or deliberating about your decision outside of a regular gavelled-in session. And what we're trying to show is that same sort of diligence, that same sort of conscientiousness or scrupulousness really ought to apply to all of your meetings and any discussion about your board business. Excuse me. So what's a meeting then? It's going to pick up your regular meetings, your once quarterly meetings. It's also going to pick up any special meetings that you say we need to have. That special meetings provision is also going to pick up emergency meetings. The only exception is your executive session. So let's talk about executive sessions. Executive sessions are very specific, very narrow things. It is when one or more of you gets together with your board's attorney and you've either been sued or somebody has threatened to sue you, and you are trying to get sound legal advice from your attorney about that. Excuse me. And so if you go into one of these executive sessions and you say, my gosh, we've been sued, or we made this decision with regard to somebody's license, for example, and that's, now we're being sued over that, or somebody has threatened to sue us over that, and we want to find out what the legal consequences of that act are, we're going to sit down with our attorney and try and hash that out and ask questions of him. That's fine, and that does not need to be publicly noticed, and that can happen behind closed doors. So if one of you asks your board counsel, what are the legal consequences of decision X that we are contemplating? And he gives you that answer. And then the one of you who asked the question turns to the other one and says, well, then in that case, I think we need to do this or have this response. That cross communication clearly falls into the arena of deliberations or debate, and you really need to get back into the session and gavel back in order to have that covered. Excuse me. Executive session is not for the purpose of deliberating about any specific matter before you or potentially before you. And that, again, would cover your, somebody has threatened to sue you, or you say, well, this is an evolving pattern that we're seeing in practice among practitioners and licensees, and we need to kind of get ahead of it. That's business potentially before you. Let me give you an idea of how far this goes, and logically you may look at this and say, this is just silly. But I'm not here before you this morning to tell you what the law should be, but what it is. There was a civil service board in Maury County a few years ago. And the civil service board, they were undertaking to do level 1 interviews. They were vetting candidates who would then go on a list from which the county sheriff's department could hire. Okay? The Tennessee Attorney General said because those first level interviews would potentially impact the people that were being hired by the sheriff's department, who in turn would have a huge impact on the public, those interviews were covered by public meetings laws and had to be properly noticed and available to the public. If job interviews are under the umbrella of Public Meetings Act, that ought to give you some kind of idea about how, especially broadly, the legislature is trying to apply this. A few examples. Excuse me. If one of you contacts Chairman Watkins and says, here's a news article that's relevant to what we do, that's fine, because you're not deliberating or discussing board business. If you say, here's a news article that's come to my attention and I think this is a real issue, and I would like it included on the next agenda, that's fine. But if you say, here's a news item about one of our licensees, I think he's a bad actor and we should consider sanctioning him or revoking his license, now you've offered an opinion about how you would vote or how you might, and so that falls into the category of debate or deliberation, and that's the line that you've crossed at that point. Sir.
Is it okay to ask a question?
Yes, sir.
Several weeks ago, I sent to the executive director a request for this presentation. I copied all of my fellow board members on that email. Was that an acceptable communication, or was that an improper communication?
That is a perfect question for your board attorney, and please don't think I'm punting it down the, well, do think I'm punting it down the road, but for good reason. That is, but you bring up a good point, and precisely at the heart of that is that you have an attorney, and I'm not it. So I'm barred from answering that question. But it's a perfect question, and by the way, that's a good question that would be perfect fodder or good substance for one of those executive session carve-outs that we talked about before.
Can I interrupt just for a minute, because we are running out of time here? I think most of us recognize that this is pretty much absolute in the interpretation of what legal is telling us. I think our frustration stemmed from the fact that we meet quarterly.
Right.
And it gets hard. I mean, for instance, this past year, I had a specific instance where Mark was going to, again, I know we have an attorney, but I just want you to be familiar with what issues we're dealing with. Sure. So we have an issue with staff where he wanted to join a NASBA or take a NASBA position, which is State Boards of Accountancy. I did not have the work. It was a decision that had to be made relatively quickly, and you couldn't notice before a decision needed to be made. And so I had no ability to check even with my executive committee on their thoughts on the matter. And again, it's a staff issue, and so that's where I'm not here. I'm in Memphis, Tennessee.
Right.
And so, Bill's here. Casey's over in Chattanooga, and so this cross-state thing presents some challenges in the fact that how do you notice a meeting properly? How do we deal with staff issues that need to be dealt with quickly when we can't talk amongst ourselves? And that I think at the heart of the matter, that's where we're trying to understand how do we become an effective board and do what needs to be done, knowing that we've got limitations on how we can absolutely do that. Because then what you do as the chairman is then in the position of just deciding, which is, I'm happy to decide. I would rather have input from my fellow board members on issues of that nature.
It's a strong frustration. It's not something, it's not a frustration that only your board feels. It's pretty universal amongst all the boards and commissions. And it's one that, having given this a couple of times now, I hear precisely that every single time I stand before or have stood before one of y'all's boards to talk about this. And so I keenly appreciate it. The short answer is that the state legislature and the courts, when interpreting these things, are keen to have you all understand that they're more interested in having it done really by the book and by the numbers, and that efficiency or speed of process is relatively far down on their priority list. The point here is that if the citizens of this great state elect a governor that they don't like, they can vote him out of office. If they elect a judge whose decisions they don't appreciate, they can find another judge. You all they have not elected. And so these sunshine laws, at their heart, are designed to provide a neck about which the public can put their hands if it should come down to that. In practical application then, your executive director, your board council are the ideal go-betweens. Is that the most efficient way of getting about it? I understand that it's not, but it is the best way to keep you all safe. Excuse me. I hope that addresses your concern, Chairman. Does it?
I mean, I understand what you're telling me.
I know.
It's
not
it
the
is what it
answer
is.
you want.
What I
Yeah.
would say is that the sunshine law,
Special meetings by electronic means if need be.
Immovable object.
Yeah, I have part of that. Yeah, that's a good.
around it at our peril. You know, we're lawyers, we're here to advise you of risks, hopefully help you avoid them. We would never want to feel like you fell off a cliff if we didn't at least warn you. Some of it is best practices. Mr. Blaufus' original question, probably, good Lord willing, we wouldn't get sued and everything be nullified if you discussed beforehand the same thing you discussed here in the meeting and repeated them all and over, but it's still not the best practice by any means. You know, as far as your question, I would just encourage you, hopefully armed with some additional knowledge from our presentation, to work through this with Mark and Chris. There are different ways to do it. You know, whether the board could meet more than 4 times a year, that may be a different.
Absolutely.
Option, but that would at least be conceptually a way to get at this.
Right.
Mr. Joseph asked me, and I'm aware of the clock, but Mr. Joseph asked me to address something, and I happen to have a couple of slides on it here, so I'm going to push through it pretty quickly. Electronic attendance may be another solution for you. Now, typically, if you have enough members here present in the room to make a quorum, and other members have to participate telephonically, that's fine. The only change procedurally that you have to make is that you cannot then do voice votes. All in favor say aye, right? You then at that point have to move to a roll call vote so that the public can know who voted what when some of the voters are not in the room, right? However, there is also a provision there at the bottom of that slide that if the in-person members are not sufficient in number to constitute a quorum, But you can get to a quorum by bringing in people telephonically. You can still proceed, and as you know, Chairman, you just have to then adopt and promulgate a statement of necessity.
And we have done that in the past.
There is some case law out there to support the notion that in times of very special circumstance and bordering on emergency, if you give proper public notice, adequate public notice, you could conduct the whole thing telephonically, okay? But even that emergency meeting is, and I'm sure you've dealt with this before, going to have to be set 2 or 3 weeks out, because even the emergency meeting is subject to the adequate public notice requirement. And that's probably going to give you all, or at least enough of you all, a chance to get here in person. But if you couldn't, there is some support for the idea that everybody could attend telephonically as long as it was noticed and the public could, for example, be here. The public has a right to attend and observe your meetings. I'll move very quickly here, but not the right to participate. You all already know that. You're not required to let anybody speak. You may choose to at your discretion, but any reasonable limits you place on that are also entirely at your discretion. You can say, well, we've only got a total of a half an hour for the public to speak on this issue. We do want to hear from you, but you only get 30 or 60 seconds each. That's fine. Adequate public notice, again, this is something that Mr. Crocker and your staff sort of takes care of, but just so you know what's going on, there is a 3-part test: contents, location, and timing. The contents have to reasonably describe the purpose of the meeting. The way that we usually do that, the convention, is by agenda, but you're not married to the agenda, as you know. It's not the 10 Commandments, it's not graven in stone. It has to be posted sufficiently in advance of the meeting in order to give the public adequate time to become aware of and attend. Excuse me. The rule of thumb there is going to be a 7-day to 10-day kind of a period. Typically, all of your meetings for the year are posted for the year at the beginning of the year on your website, and that brings us to the location of the notice. There are a couple of different usual methods by which the Attorney General and the courts have said that we can cover ourselves in terms of the location of the notice. We publish the notice on the Department of Commerce and Insurance's website, on your accountancy board website, and then the day of the meeting, of course, we post a bill in the lobby to let people know where the room is. Excuse me. All right. At the end then, the Public Meetings Act is designed to make sure that all of your business is conducted in a way that's accessible to the public. That includes deliberations, debates, decisions. It definitely applies to you both as a board and as individual board members, but not as individual citizens. Mr. Whitaker, your board counsel, is the board's attorney, and he can answer legal questions for you in your capacity as board members, but he is not your personal lawyer. You already know that, but it bears repeating. Anytime more than one of you is in the same room and you're talking about board business, you are very, very, very likely to be covered under this Public Meetings Act, and playing it safe is better than not. But we've talked about some ways that we hope will be good workarounds for you, either communicating sort of laterally through your executive director, Mr. Crocker, through your board counsel, Mr. Whitaker, and the possibility of having a meeting where all of you participate electronically. Excuse me. At the end there, I say the best way to cover yourself is be paranoid. Paranoia is probably too strong of a word, but scrupulousness and attendance to the spirit as well as the letter is not going too far. And that is all I have this morning. I appreciate your time and your patience. If any of you has 1 or 2 quick questions, I think we can probably squeeze them in at this point.
I have a quick question.
Yes, ma'am.
Just to clarify, let's say I have gotten, I know what's going to be on the board, but I have a question dealing with maybe a clarification of the rule. Nothing to do with the actual well, it is related, but I want clarification before going to the board meeting. It's all right to call my attorney, Chris, but I should not discuss that rule clarification, say if I run into Mr. Watkins.
That's absolutely correct, and
You
that's.
can always talk to staff, right? I mean, even
I can-
Mark would be okay.
Sure, yeah, Mr. Crocker, Mr. Whitaker, both are your perfect go-tos, your perfect solutions for that exact kind of a thing.
I think that's a great question. So it's a great answer, right? We're not trying to puzzle y'all at all. We're not trying to tell you where to be, when to be there, and what to think about, or what opinions to have about the votes when they come up. We're simply, and it is a little bit of a mindset adjustment, but to the extent that you're on this board and honored to be on this board, we're trying to reorient the deliberations. And yes, discussions are not deliberations, but that's a real fine line, and we want to keep you out of that. Communicating with Chris as counsel or Mark as executive director, that's perfect.
Mr. Blakey?
In order to comply with the law, which, let's see, my only objective is, in recent times, Mark has needed to send board information or financial statements. He is sending it to us individually rather than as a group. We don't know whether the rest of the board members are receiving the same information. That necessary in order to comply with the law?
What, that you're all receiving the same information?
Yes.
I think it would certainly be preferable that you're all receiving the same information.
And that we know that
but-
we're all getting the same information.
Can't send like a
Mr.
group
Crocker's-
email.
That's Mr. Crocker's responsibility, frankly. It's his job and Mr. Whitaker's job to make sure that the same version of the same documents are getting promulgated to each of you at the same time so that you have the same opportunity. If one of you is getting a document that the other one is not getting, and it pertains, for example, to a formal hearing, and that were to bias your deliberations, your decisions, that would be problematic. But that's not something that you have to worry about as an individual board member. That's Mr. Crocker's job, or alternatively, Mr. Whitaker. So it's a good question,
Well, yeah,
but it's not on your plate.
I agree with that answer. Let's not, for the groups, skip over the initial embedded question in there. I think there's, for lack of a better term, a method to the madness. What Mr. Crocker is trying to do, and this is good open dialogue, and maybe in the future we could be more clear, so that there's no question that each of you, albeit individually, is getting the same thing. It would only be an exceptional case where you wouldn't be able to send something to one person.
And let me,
But the method to the madness, excuse me, the method to the madness is this. If he emails just Mr. Blaufus, he can be assured, as a matter of best practices, that we don't get a reply all, and then all of a sudden, the well-meaning thoughts and opinions of Mr. Blaufus become deliberations. That's the method to the madness. That's on purpose, and that fits with what we're saying.
for example, just to carry this example home, Mark sends out the financials for the upcoming budget year, and he's doing them individually. To say, he could type in a sentence in the email, say, this is, these financials are being distributed to the board members, whatever he wants to say. But by sending it individually, as Sam pointed out, usually the reply and the reply all buttons, especially in like Microsoft Outlook, are right next to each other. So you hit the wrong one, even if you didn't mean to, and it reply alls to everybody. That's, again, it's a little bit of an extreme example, but at the same time, someone who is motivated enough to challenge something that the board did after the fact substantively will be motivated to look for any possible method by which to undo that. So that's the why. But
And that touches on the last point that I will make today. There are dozens and dozens of cases, folks, that came before Tennessee courts on this very matter. And, as Sam mentioned, I'm not here before you today to muzzle you or make your lives hard. I know it sounds that way, but I promise I'm not. Our job here and the purpose of this presentation is to help keep you safe. And then by extension, to help keep your actions covered and sound so that your licensees and the good work that you do for the public can go on unimpeded. It is possible, and I've read all these cases, it's possible to get sued for a violation of the Sunshine Law and then win. I would propose to you, however, that if you get sued, you've already lost. Right? The amount of the vast amount of staff resources, your time, public funds that get just sunk into the black hole of defending that is just really a place where you don't want to go. And that was the point, really at the heart of my purpose being before you here today, to help keep you well away from the cliff.
Well, good, thank you, Chairman Watkins.
Thank you.
Thank you, John. Jesse, thank you. I'm sorry to keep you waiting.
Mark,
What-
oh, sorry, go ahead.
What was the time limitation? Why did we have to have a limited time on this?
I just think it was for the formal hearing. I think because we had noticed the formal hearing at 9.
But I'll be happy to come back. And
On the agenda,
We'll come back. We were kind of working off several balls. Damon has class today, and I didn't want to presume that he would skip class. We had the ALJ for the formal hearing. We understood y'all were really trying not to go through or past lunch, but we spent a lot of time on this, so we're happy to come back however we can make that happen.
And if the coming back is just an extended Q&A, I'm happy to accommodate you at any time of your choosing. I hope that helps.
is what it is.
We appreciate your time and appreciate the questions.
Thank you. Mark, do we need to take a brief moment to let the court reporter and everybody get set up?
Yes, please.
Okay, we'll take a quick recess here for a minute. Officially opening the.
We got to wait on our
Okay,
court
sorry.
here.
Who are attorneys? Like you would have
Jesse
target on
Joseph.
your back as CFO.
And then Mr. Reno's unrepresented.
Something goes wrong. Okay.
Court reporter's getting set up. Let me see, the Joseph Reno matters we're going to hear. Is anybody here on the John Hamblin or the Stanley Pickering matters? Joseph, which one, Hamblin's going to continue,
Yes, sir.
and you've got an agreed order on Pickering?
Yes, I've got an agreed final order.
You're going to take that up this afternoon with the board or after
Well,
this?
I was hoping that my normal practice is to take that up during the legal report. Or legal report document, not that, it was simply just settlement.
All right, and then the Hamlin, you're going to send me an order with a new date on it?
Yes, sir.
All right, great. So, Mr. Joseph, you have one witness, you say?
No,
And Mr. Reno, you have no witnesses?
no witnesses.
All right. Your witness, Mr. Joseph,
Crocker, Executive Director of the Board.
is he also the party representative?
Yes, sir.
All right. Do you want him to step up with you there, or is he back, he's in the audience, it's up to you.
Wherever he feels comfortable. If he wants to sit.
It's okay. I just wanted to make sure he's designated as the party representative also.
I don't have your name.
All right, Mr. Watkins, if you'll open the meeting, I'll take it from there.
All right, we're moving into the formal hearing, and I would like to just go ahead and turn that over to Your Honor.
All right, thank you, Ms. Watkins. All right, today is January the 31st, 2014. We're present in Nashville, Tennessee for a hearing before the Tennessee Board of Accountancy. The board will consider the case of the State versus Joseph D. Reno, CPA license 4906, firm permit number 1024. This is APD docket number 12.19-124015A. My name is Steve Darnell. I'm an administrative law judge assigned by the Tennessee Department of State Administrative Procedures Division. I've been designated to sit with the board today and conduct this contested case hearing. As such, I'll make all rulings regarding the order of proceedings, admissibility of evidence, and procedural questions of law pursuant to the Administrative Procedures Act. In other words, it's my duty to conduct this hearing, regulate the course of the hearing, and rule on any evidentiary or procedural legal issues involved in the hearing. I will not participate in the findings of fact or the ultimate decision made by the board. That's the decision for this board only. At this time, I'll ask the members of the board to introduce themselves on the record. We'll start with Mr. Hoss if we can and work around.
Yes, my name is Henry Hoss, H-O-S-S.
Jennifer Brundage.
Vic Alexander.
Stephen Eldridge.
William Blofus.
William Watkins.
Casey Stewart.
Gabe Roberts.
Charlene Spiceland.
All right, and our board today is chaired by Mr. Trey Watkins. Ms. Watkins, is this a quorum of this board?
There is a quorum.
All right. All right, counsel for the state, first we'll ask you to introduce yourself and who your party representative is.
Yes, Your Honor. My name is Jesse D. Joseph, Assistant General Counsel for the party representative is Mr. Mark Crocker.
All right. Mr. Reno's present. Mr. Reno, you're not represented by counsel, is that correct?
That's correct.
All right. Do you want to introduce yourself to the board?
Joseph Reno.
All right. Thank you, Mr. Reno. Members of the board are reminded that during the time this hearing is being conducted, there's to be no discussions concerning this case between members of the board and the judge, the witnesses, attorneys, other board members, or any other person unless all parties are present. During the hearing, the board sits as a jury and must only consider the evidence introduced in the hearing in reaching its decision. The Tennessee Sunshine Law, or the Open Meetings Act, requires that all board discussions and deliberations be in public before all parties. Failure to observe the Sunshine Law will likely result in the board's action being reversed or remanded if appealed to court. Board members, you're reminded that the law requires you to disclose on the record any outside knowledge you may have of this case or communications, written, verbal, or otherwise, from any of the parties concerning this case. And any member of the board have any knowledge of the Joseph D. Reno matter? All right. I'm getting no's and head nods, so for the record, no members indicated they have outside knowledge. Before this hearing begins, I'm going to give you some instructions to help you understand how this case will proceed, what your duties will be, and your conduct during the hearing. When I've completed these instructions, the attorneys, or Mr. Reno, who's pro se, will make an opening statement. These statements will be brief outlines of what the parties expect the evidence to show. After the opening statements, you'll hear the evidence. The evidence generally consists of the number of exhibits and testimony of the witnesses. The state has the burden of proof, so the state will present its evidence first. The respondent will then be given an opportunity to present his evidence. Although the evidence is presented by asking witnesses questions, the questions themselves are not to be considered as evidence. During the course of the hearing, there'll be an opportunity for each of you to ask the witnesses questions as they testify under oath. Your questions time should be used to develop relevant evidence to the case that will assist you in reaching a decision. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of this action more probable or less probable than it would be without the evidence. You should reserve any expression of opinion you may have on the facts until that portion of the hearing which is set aside for the board's deliberations, after all the proof in the matter has been heard. During the hearing, objections may be made to evidence or procedures. I may sustain objections to questions asked without permitting a witness to answer, or I may instruct you to disregard an answer that's been given. In deciding the case, you may not draw any inference from my rulings on these issues. When all the evidence has been presented to you, the attorneys, or Mr. Reno, who's pro se, will make closing arguments. The attorneys will point out to you what they contend the evidence has shown, what inferences you should draw from the evidence, and what conclusions you should reach. The state will make the first closing argument, followed by Mr. Reno's closing arguments. Statements made by the attorneys are not evidence. Attorneys' statements are made only to help you understand the evidence and apply the law to the evidence in the case. You should ignore any statement that the attorney makes that you do not feel is supported by the evidence. After closing arguments made, I will give you further instructions of how to resolve this case. All right, with that said, Mr. Joseph, do you have a notice of hearing to publish to the members of the board?
Yes.
All right, let's go ahead and do that. Mr. Reno, this is a copy of the document that was provided to you earlier that initiated our proceedings. And members of the board, we'll take just a moment and let you review that so you'll understand why we've all been called here today. right, members of the board, are we ready to move on, or we need a little more time? Everybody's ready to go? All right, Mr. Joseph, I'm going to ask you, since Mr. Reno is self-represented, and members of the board, it's difficult for a self-represented party, especially one that's going to testify, as I understand Mr. Reno is, to make an opening statement, because his testimony under oath is so intertwined with what he wants to tell you about his argument. Mr. Joseph, I'm going to ask you just to make a short, non-argumentative, argumentative statement as possible, and kind of just lay us a little foundation for why we're here today. Mr. Reno will hear the proof, and after you've testified, I'll remove you from your oath, and you'll be able to make any closing arguments you may want at that time. All right, so Mr. Joseph, can you tell us in a summary fashion why we're here today?
And held himself out.
All right, thank you, Mr. Joseph. All right, Mr. Joseph, what's your first offer of proof?
Your Honor, as exhibit number 1, we hope that there is no objection to this, but just for the record, we have pre-marked exhibit number 1 to be a copy of the certified mail return receipt, simply reflecting that the respondent was served with the notice of hearing and charges at least 30 days before the date of this hearing.
All right, I'll mark that, or it's pre-marked, you say, as exhibit 1?
Yes.
All right, be admitted into evidence. Mr. Reno's here today, obviously, members of the board, so service is not an issue. But Mr. Joseph wants to make sure his record is proper, so you can take a moment to look at that. All right, what's next, Mr. Joseph?
Your Honor, we'd like to call the board's executive director, Mark Crocker, as our first witness in this matter.
All right, Mr. Crocker, if you'll come up and take our witness stand beside Mr. Hoss. Let you get settled there and raise your right hand. I'll place you under oath. Do solemnly swear or affirm to tell the truth and nothing but the truth, so help you God?
I do.
All right, would you state your full name for the record, please?
My name is Mark H. Crocker.
All right, thank you, Mr. Crocker.
Mr. Crocker, are you an employee of the Tennessee Department of Commerce and Insurance?
I am.
And what is your business address, sir?
The business address is 500 James Robertson Parkway, Nashville, Tennessee.
How long have you been an this board and the department?
I've been an employee of the board since August of 2004.
And what is your title, sir?
My title is Executive Director of the Board of Accountancy
How long have you served as executive director for this board?
since October of 2007.
What are your general duties as executive director?
To maintain adequate records, to run the office on a day-to-day basis, to renew licenses and that type of thing.
Are you the custodian of the board's records?
I am.
Do you know the respondent in this,
I have met Mr. Reno previously, yes, sir.
and how have you previously come into contact with Mr. Reno?
When I was the investigator, I investigated Mr. Reno for a previous violation. Does.
And what is his CPA license number?
His license number is 4906.
Does he hold a CPA firm permit?
Yes, sir, he does.
And what is his firm permit number?
Firm permit number is 1024.
Okay. When is his CPA license scheduled?
CPA license is scheduled to expire 12/31 of 14.
When was his firm permit first issued?
The first firm permit appears to have been issued in 1993.
When is his CPA firm permit scheduled to expire?
Firm permit?
Right.
Firm permit is scheduled to expire 12/31 of 14.
Okay. When was the respondent first licensed?
First license is a CPA. May I consult the record? Certification date was September 27th of 1978.
All right. What is the respondent's last known address, Mr. Crocker, according to the books and records of?
324 Lancaster Square, number 1, Memphis, Tennessee.
Are you,
Yes, sir, I am.
and how did this complaint against the respondent, which we are here on today, come about?
It came about through an anonymous fax that we received indicating that Mr. Reno was advertising as a CPA firm.
And what did your office do after receiving?
We opened a complaint against Mr. Reno.
Copy of the document which I'm showing you now for identification purposes, a copy of the complaint that your office opened against the respondent, Mr. Reno, as well as a copy of the complaint signed by Karen Condon of your office.
Yes, sir, this is it.
Just don't publish it to the board yet. Let's see, Mr. Reno, you have any objection to it being admitted into evidence? All right, you can go ahead now, Mr. Joseph. So this document's pre-marked as Exhibit 2.
Your Honor, we ask that that be entered as Collective Exhibit 2, which is the complaint letter, as well as a signed copy of the complaint by Ms. Condon.
All right. Our members of the board will take just a second, let the members look that document over, a collective document. All right, Ms. Joseph.
Mr. Crocker, what is this next document which I'm presenting to you now for identification purposes?
This is a letter from Mr. Reno that we received on February the 14th, 2013. A letter to Karen Condon as a result of the complaint.
All right, Mr. Reno, any objection to this being admitted into evidence? No. All right, be admitted and marked as Exhibit 3. You can go ahead and publish that, Mr. Joseph.
Thank you, Your Honor. This is a letter accompanying February of this year, last year. Sorry. Crocker, in addition to this letter, that's been entered into evidence as Exhibit number 3, was there an actual CPA firm permit which accompanied this letter?
There was
From the respondent?
There was an application for a firm permit, yes, sir.
Is the document which I'm showing you now a copy of the respondent's application for firm permit which accompanied Exhibit number 3?
Yes, sir, it is.
Any objection? Mr. Reno, take a second to look that over.
No.
All right, be admitted and marked as Exhibit 4, and you can publish that to the board if you want to, Mr. Joseph.
Thank you. Crocker, did your office receive a copy of an advertisement from the respondent?
We received a copy of an advertisement, Mr. Joseph. I don't think it came from the respondent.
Did you receive a copy of an advertisement bearing the respondent's name?
Yes, sir, we did.
Document which I'm showing you now, a copy of the anonymous advertisement that was sent to you regarding the respondent.
Yes, sir, it is.
Do you maintain a true and correct copy of this document within your official books and records?
Yes, sir, we do.
Do you have a business duty to do so?
I do.
Your Honor, we ask that the copy of the respondent's advertisement faxed to the board office on January.
All right, any objection, Mr. Reno? No. All right, be admitted and marked as 5, and you can publish that to the board. Thank you.
Crocker, at the time your office received this advertisement on behalf of Mr. Reno as CPA, which has been entered into evidence as Exhibit 5, did the respondent have an active CPA firm permit at the time your office received?
No, sir, he did not.
What decision did your office make on the respondent's application for firm permit?
We received the application on February the 13th. We processed it and approved it on February the 22nd in order to bring him into compliance.
copy of the letter which I'm showing you now for identification, a copy of your letter to the respondent approving his application for his firm permit to be reactivated.
Yes, sir.
Did you sign that letter?
I did.
And did you mail it to the respondent?
We did.
Do you maintain a true and correct copy of this letter within your official books and records?
Yes, sir, we do.
Do you have a business duty to do so?
I do.
Your Honor, we ask that the February 22nd, 2013 letter to the respondent approving his application for CPA firm.
Objection, Mr. Reno? No. All right, be admitted marked as 6, and you can publish that to the board.
What is this next document which I'm presenting you now, sir, for identification purposes?
This is the affidavit that Mr. Reno gave to the investigator when he visited him on April the 3rd, 2013.
Copy of this affidavit within your official books and records regarding the respondent's complaint and your investigation in this matter?
Yes, sir.
And do you have a business duty to do so?
I do.
Your Honor, we ask that a copy of the respondent's April 3rd, 2013 affidavit provided to the board investigator in this complaint be entered into evidence as exhibit number 7.
Objection, Mr. Reno? No. Be admitted marked as 7 and can be published to the board.
Thank you. What is a copy of this document which I'm presenting to you now?
This is a response from Mr. Reno dated September 26, 2013 to Mr. Whitaker, a response to the complaint.
Do you maintain a true and correct copy of this response submitted by Mr. Reno within your official complaint file in this matter?
Yes, sir, we do.
Do you have a business duty to do so?
I do.
Your Honor, we ask that the September 26, 2000 faxed by the respondent to Mr. Whitaker be entered into evidence as exhibit number 8.
Any objection, Mr. Reno? All right, without objection, be admitted marked as 8 and can be published to the board.
Crocker, has the respondent been disciplined previously?
Yes, sir, he has.
Document which I'm showing you now.
This is a final order against Joseph Reno and Joseph Reno CPA accounting firm. Contested case hearing heard in Nashville on September 13th, 2011.
Do you maintain a true and correct copy of this?
do.
And do you have a business duty to do so, sir?
I do.
Your Honor, we ask that the September 2011 final order entered against Mr. Reno in docket number 12.191134628 be entered.
Objection, Mr. Reno? All right, with that objection be admitted and marked as Exhibit 9 and may be posed to the board. Let's give him just a moment to read that. Did you have other proof from this witness?
Just a couple of questions,
Okay.
but that's all of the documents.
All right, great, Ms. Joseph. Let's take just a moment and let the board look at this one. It's a little longer than our
Sure.
others. All right, members of the board, we're ready to move on, or we need a little more time? Looks like everybody's.
Tucker, regarding exhibit number 5, which was the final order entered in 2011.
Said 5, I think you meant 9. I'm
sorry.
Respondent's failure to timely renew his firm permit and his CPA license.
Respondent what?
I'm sorry. Respondent's failure to timely renew his firm permit and his CPA license. Respondent's provision of accounting services out of an unlicensed firm. And respondent's failure to respond to board correspondence in a timely manner.
Between
Mr. Reno closed his firm permit on October the 20th, 2008.
So did he have a firm?
No, sir, he did not.
All right, thank you, Mr. Joseph. Mr. Reno, do you have questions you want to ask Mr. Crocker? I'm going to give you an opportunity to ask him questions. You'll have an opportunity to testify under oath in a moment also. I think you're our next witness, actually. But now, if you have any questions, anything he's testified to, you want him to clarify, any additional information, now's your opportunity to get that from Mr. Crocker.
Yes, sir. What,
Speak into the microphone there a little bit if you can.
in applying for a new firm permit, when is it determined that a firm begins to exist?
When you begin to advertise or offer accounting services.
Not from the date that you actually generate business?
No, sir, I believe the statute reads if you're offering to perform accounting services, then you must have a registered firm.
I read from the rules of Department of Commerce and Insurance.
Mr. Reno, let's see if, Ms. Crocker, do you have the rules?
I don't have.
Can we get him a copy of those? Mr. Reno, why don't you draw the witness's attention to whichever rule you want to question him about?
I'm referring to Chapter 0020, 01-12.
All right, now the witness has that rule. What's
Yes, sir.
your question of him, Mr. Reno?
The rule states that the firms established shall file with the board a written notification of any of the following events concerning the practice of public accounting within the state within 30 days after its occurrence.
Is that what the rule provides, Mr. Crocker?
Yes, sir, that is what the rule provides.
All right. So what's your question about that, Mr. Reno?
It would seem like that you don't have to establish a firm until 30 days after you initiate, not before. You're saying it should have been done prior to sending out the advertising, and this seems to state that within 30 days of doing that, I can file for a firm permit.
That's the question to you, Mr. Crocker. Is that a correct interpretation?
This is for the formation of a new firm, Mr. Reno. You did not have a new firm. You were reopening an old firm.
The application says initial application for a registered accounting firm. The initial, to me, would, you said my firm was closed in 2008.
Yes, sir.
You testified to that.
Yes, sir.
And now I'm applying for a new firm.
You're reopening an old firm.
How would I know that I was reopening an old firm and not, why would, if the application says initial application, that seems to be the first application. Initial to me means first.
Well, the procedure is you're reopening an old firm because we don't reassign a firm number. We reopen your old firm.
How would I know that?
I'm not sure that you would, Mr. Reno.
Other questions, Mr. Reno? Before the board questions the witness, any redirect, Ms. Joseph?
Mr. Crocker, in possession of the board's laws and rules in front of you.
Yes, sir.
Can you look with me?
Yes, sir.
Do you have that in front of you?
I do.
Can you locate subsection D of that section?
Yes, sir.
And part 1 under subsection D, what is your interpretation, sir, of Tennessee Code annotated 621?
Well, this says that no firm shall provide or test services or indicating that such firm is a CPA firm unless the firm holds a valid permit.
And do you consider that respondent complies?
No, sir.
Thank you.
All right. Any follow-up to that, Mr. Reno?
The section that I quoted seems to be in conflict with that, which says that within 30 days after its occurrence. Which is right? Now or 30 days from now?
Question to you, Mr. Crocker.
That's a matter for the board to determine, Mr. Reno.
I can tell you that I relied on the 30-day.
Let's wait till you're under oath and you can tell the
Okay.
board members that.
One more final.
All right, we'll go one more round, then we'll let the board
Mr.
ask
Crocker,
questions.
can you turn with me again to the rules section that Mr. -01 dash
Yes, sir. Yes, sir.
Why is that?
Because he had previously practiced as Joseph D. Reno CPA, and we had a firm permit that had been properly closed.
But what would that permit active in order for him to be an established firm?
That's a good question, Mr. Joseph. I'm not sure I can answer that.
What I'm essentially asking you, you do see the language firms as,
Yes, sir.
so would the respondent's firm have been,
I believe so.
why, in your opinion, does the 30-day period not apply to grant response?
Because Mr. Reno had previously practiced and had a CPA firm permit that he properly closed.
You simply do not consider this the formation of a,
No, sir.
do you have any other applications that your office uses?
No, sir, we don't.
So your testimony is that you use that same application?
Yes, sir.
And why would you not have granted Mr. Reno a new firm?
Because we already had a file established under 1024, and he was simply reopening that firm.
Thank you.
Any follow-up to that, Mr. Reno, before the board questions the witness?
Why would you not have a form to reestablish a closed firm?
We've just never generated one, Mr. Reno. It's probably one that we need to get put out there for you.
I think you're right. You do need to do that because people like myself have
Mr.
no way
Reno,
of knowing.
save that for closing argument.
Okay.
You have another question for the witness? Any other questions?
No, I'm done.
All right, thank you. All right, any member of the board have question for Mr. Crocker? Nope. All right. Thank you, Mr. Crocker. We'll let you step down then. Other proof, Mr. Joseph?
No further proof, Your Honor.
All right.
Go to closing.
We're going to let Mr. Reno.
I'm sorry. Pardon me.
Crocker, get situated there. Mr. Reno, you're going to testify, is that correct?
Yes.
All right. Let's have you step up to the stand here so Mr. Joseph can see you, Mr. Whitaker.
To hear.
Right there where Mr. Crocker was sitting, sir. If you'll raise your right hand once you get situated, I'll place you under oath. Do you solemnly swear or affirm to tell the truth and nothing but the truth so help you God? All right. Would you state your full name on the record?
Joseph D. Reno.
All right. Thank you, Mr. Reno. Tell the board what you want them to know about this.
As I've written in the evidence that you've presented this morning, I sold my accounting practice in October of 2008. I was approached by Corey Phillips prior to that, wanting to buy my firm, and I told him I was not ready to sell the firm. I just wasn't part of what I was doing at the time, but he persisted. We talked. We agreed that I would sell him the firm if I could stay on as an employee for 5 years. We wrote that into the contract. And that 5 years would have concluded sometime in 2014. But on the last day of tax season, and this was April 2013, Mr. Phillips came to me and said, I don't want to continue our relationship. And I said, well, we have a contract that will cause you, if we don't, I'm going to have to sue you. We're going to have to litigate this. This would be ridiculous to do that. And he said, well, do what you have to do. This was in April of 2012. So I cleaned out my office, left the firm, and began to some litigation procedure. And and sometime after terminating my employment, I filed for and received unemployment benefits because I was indeed an employee of the Phillips CPA firm. I continued to receive unemployment benefits up through the end of 2012. The litigation got stalled, as litigation does. My attorney was talking to his attorney, blah, blah, blah. Nothing happened. And so, and I, at the end of, or in early January of 2013, former clients were calling me saying, Joe, are you still in business? And I say, no, I'm not. Well, can you refer me to someone? I'm not going back to the Phillips firm. And so at that time I thought, well, maybe I should go back in business. People are wanting me to continue doing their tax returns. So to test the waters, I sent out the postcard that you have in evidence here. The complaint was filed by Phillips. I know that because if you'll look on your card, there's a fax number where he faxed it to the board, and that is the fax number from CPA Phillips CPA firm. So Corey Phillips filed the complaint, which is part of we have a war going on. That's part of the little battle, and and as a result of that is why we're here today, I guess. But I sent out the letter or the postcard, kind of testing the waters to see if there was indeed reason for me to get back in business, to go to the expense of buying software and setting up again. And so at that time, I immediately got response saying, "Oh, I'm so glad to get your postcard, blah, blah, blah. I'll be calling you to do tax services." And it, ironically, I had on my desk the firm application, the initial application for firm permit, and was filling it out the day I got the certified letter from Ms. Condon. And I immediately called her and told her the circumstances of what had happened. I was filling out the permit. She said, "No problem, just put an explanation, send it in." I did, thinking the matter was resolved, until the investigator showed up in April about this issue. I did the affidavit that you have in evidence. And again, the matter left my mind. I thought it was resolved until I got further. Then I got the notice of being fined $1,000 for this. I filed the appeal, and then we end up here today. But the basis of my appeal and my belief that I'm not in any violation is that I did indeed file the permit for a new firm, which I thought I was doing for a new firm, within 30 days of doing any business. Of course, I didn't do any business until late January, early February, because of this. The only thing I did in January was initiate the postcard. So my testimony is that I don't feel like I'm in any violation of anything, and think it's kind of absurd that we're doing this today.
Questions, Mr. Joseph?
No, Your Honor.
All right. Any member of the board have question for Mr. Reno?
I'll ask one, Mr. Reno. Oh, sorry, Henry, you want to
Go
go?
ahead. Go ahead.
Did you, it says here that your firm permit expired on December 31, '07, and that you sold your practice to another CPA firm in October of '08. That's right. Does that mean that you were operating in '08 until the sale of your business without a proper firm permit?
Yes, it does, and that was totally inadvertent. And I testified to that when I was here in 2011. That certainly I wouldn't do that on purpose. A $50 application fee is not a reason for me not to do it. It was inadvertent, and I paid the price.
All right, other questions?
Mr. Reno, you indicated that in January you were trying to test the waters to see what possibilities there may be out there for doing tax returns. Can you tell me when you obtained your PIN number from the Internal Revenue Service?
Back when they required PIN numbers to be obtained, and I had a PIN number. Are we talking about?
Well, the registration number you have with the Internal Revenue Service.
I had to use that when I was an employee at Phillips. Yeah, so whenever the IRS required us to have PIN numbers is when I obtained it, and I'm not even sure when that is.
Did you transfer it over to the new firm? When did you transfer it over?
It was in my name personally.
Okay.
And so I used it when I was an employee at Phillips, and I continue to use that same PIN number.
Questions?
I have one, Mr. Reno. When you sold your firm back in 2008, I guess you surrendered your firm permit or terminated your firm. Did you file all the paperwork you needed to dissolve your firm as far as?
Apparently I did. Mr. Crocker testified to that it was properly surrendered.
Questions?
I have one question. I'm looking at the postcard that you sent out, and just want a little bit more about your thought process. Were you advertising that you had a firm, or was this you? Tell me just again a little bit more about what.
Yes, I was
this-
telling people that I was available to do tax returns.
And this is sent to former clients that you knew about that might have an interest for you to do their tax returns.
That's right.
And you sent this out in January,
Yes.
but didn't do any work for these potential clients in January.
I guess we begin filing tax returns, first part of February.
Other questions from the board? Correct, Mr. Joseph? All right. Mr. Reno, anything else while you're under oath you want the board to know as testimony from you? I'm going to give you an opportunity to make any arguments you want to at the closing here.
No, I think it's evident that, during this period from 2008 until I reestablished the firm, or until I initiated the firm permit, that I had been an employee of Phillips, that I was unemployed until that time, and then went back into business in around the 1st of February of 2013. And that I relied on the fact that I had this window of opportunity to make my initial application for a firm permit according to the law as I read it.
All right, thank you, Mr. Reno. Any questions from the board before Mr. Reno leaves our witness stand? Anything further, Ms. Joseph?
Nothing other than closing, Your Honor.
All right. Mr. Reno, you can take your seat back. Mr. Reno, you had no other proof, correct? All right. Closing comments, Ms. Joseph?
Yes, Your Honor. We have written proposed findings of fact, conclusions of law, and a proposed judgment, and I'd also like to be heard in a brief oral closing.
All right, you can
Like me to
distribute.
publish this first, or?
You certainly can,
Thank
and
you.
We'll hear your closing comments. And Mr. Reno, you're no longer under oath. I'm going to magically remove that from you, and you'll be able to make any closing arguments you want to. Members of the board, Mr. Reno's closing arguments from this point on, and also Mr. Joseph's comments are not evidence and not to be considered by you as such. Ms. Joseph, we're ready when you are.
Preliminarily, as a matter of law, the state would as the board is aware, based on the rule, 30-day period, as far as we are able to read and interpret. Notification to the board of a formation within 30. statutes that are applicable seemingly with respect to the proposed findings and conclusions in this case, the state believes it is proved by evidence all of the allegations included in the proposed findings of fact, and consequently that the conclusions of law are also proven. Proposed findings of fact number 1 included within your proposed findings. This board and the court can take position no regulatory boards, Department of Commerce and Insurance, proposed finding of fact number 2 is proven by the testimony of the board executive director, Mr. Crocker, and the books and records of this board regarding which he is the executive director. Proposed finding of fact number 3 is proven by the copy of the board's final order entered in 2000 advertisement itself, which was exhibit number 5, his affidavit admitting the fact that he did advertise, exhibit number 7, and his response letter to the complaint, exhibit number 8, and also by the testimony of Mr. Crocker. Is proven by the respondent's CPA firm permit, fact number 4 is also proven by Mr. Crocker's letter reactivating the expired firm permit, which was dated February 22nd. Proposed finding of fact number 5 is proven by the final order of the board in docket. Based upon all these proposed findings of fact, the state contends that the respondent, through his actions, did violate the cited authorities, to wit, Tennessee Code Annotated Tennessee Code Annotated 62-1-130. That the respondent has violated these provisions during the month of January 13 and the board has the authority to issue a civil penalty, as it is aware of, up to $1,000 per. Certainly, the board could impose a higher civil penalty than what the However, given the respondent's submission of his firm permit application in February, the state is requesting only the imposition of a $1,000 civil penalty in total. But at the same time, this type of activity has occurred
Thank you, Ms. Joseph. Mr. Reno, closing comments, and you're welcome to use your seat there, use the podium, however you want to proceed.
Hard to know where to begin. I feel that I've not violated any laws at this point. I don't know how an applicant can know if he is reinstating a firm or applying for a new firm. The regulations do not tell us that. And Mr. Crocker has testified that there's no way of knowing. And I would ask the board members, if you were going through a situation as I've gone through and doing what I've testified that I did, would you have done anything differently? I mean, look into your mind and say, would I really have done anything differently than Mr. Reno did about applying for the firm, not even knowing that you were indeed going to perform accounting services when you were seeing if there was indeed business out there, if there was a reason to do this, if it was worth the investment of your time and expense of buying software and equipment and that sort of thing before you even, at my age, I didn't want to start a firm at 70 years old, but if there was business out there that I did not have to initiate and go after, I thought, well, perhaps it's worthwhile doing, especially in light of the fact that a contract had been violated, that I had planned on having 5 years of income and not going back into business, but I've felt entitled to do what I did as far as saying if there was indeed a reason to prepare tax returns again. I don't think we resolved the issue, and I paid a fine in 2011, and I think we established at that hearing that was something that was inadvertent on my part. Not paying the $50 I was not trying to cheat anybody out of $50. It was just inadvertent, and we resolved that issue, and that should not be bear on the thought process of this board that I'm a habitual criminal in this matter. As far as I think you should look at that as a matter that was presented, resolved. I paid the fine. I felt imposed on, but it was over and done with. With this situation, I feel no guilt at all. I feel like I did what was what I should have done under the laws that I read, and that in good conscience the board would have to see that I indeed went by the letter of the law as I read it and as it was testified that is written. So that's pretty much my my testimony at this time.
Thank you, Mr. Reno. Anything further, Mr. Joseph?
No, sir.
All right. Anything further, Mr. Reno?
No.
All right, members of the board, I'm going to read you a shortened charge. I think the matters in this case are fairly clear cut. I know you'll be disappointed not to hear the long charge. I understand, but as members of the board, you must make findings of fact based upon the evidence presented to you at the hearing. The notice of charges filed by the state is not evidence, but you may use the notice of charges as a guide to assist you in making your findings. But it's your sole responsibility of the board to make your own findings of fact in this matter. You can use the proposed findings of fact supplied by the state also as a guide, but only after careful consideration and a determination that the notice or the proposed findings of fact of law accurately reflect your independent recollection of the evidence and your own conclusions. The state has the burden of proof in this case. It's the state's burden to establish all the findings of fact, all the facts necessary to prove each and every violation alleged. The respondent does not have the burden of proving that he is innocent of the charges. State must prove the case by preponderance of the evidence. A preponderance of the evidence means that amount of evidence that causes you to conclude that an allegation is probably true. To prove an allegation by preponderance of evidence, a party must convince you that the allegation is more likely true than not. If the evidence on a particular issue is equally balanced, that issue has not been proven by preponderance of the evidence, and the party having the burden of proving that issue has failed. You must limit your inquiry regarding violations of your statutes and rules to those violations which are alleged in the state's notice of charges. For instance, if you believe the respondent has violated a statute or rule which has not been alleged in the state's notice of charges, you may not inquire into or address violations not set forth in the notice of hearing. Members of the board, you are the sole and exclusive judges of the credibility and believability of the witnesses who have testified in this case. You must decide which of the witnesses you believe and how important you think their testimony is. You are to decide the case only from the evidence which is presented at this hearing. The evidence in this hearing consists of the sworn testimony of the witnesses who have testified and the exhibits which were marked and entered into evidence. In making your decision, you must consider the evidence in light of your own reason, training, experience, and common sense. You cannot base your findings on speculation, surmise, or conjecture. In determining whether a civil penalty should be assessed and in what amount, the board may consider the following factors: whether the amount imposed will be an economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation and the risk of harm to the public, the economic benefit gained by the violator, if any, as a result of noncompliance, and the interest of the public. Members of the board, you may consider any evidence that the parties have introduced on the issue of appropriate disciplinary action, including whether or not the conduct was or is of a continuing nature or whether it was a one-time offense. Excuse me. Any motions to adopt findings of fact to find that the respondent has or has not committed violations of statute or rule, motions to formulate discipline, if any, and state policy reasoned by the board, action must be carried by simple majority vote of the board. The policy reason statement is required for your order, in your order by the Administrative Procedures Act. The board's policy reason states why your decision in this situation is appropriate, given the circumstances of this particular case plus other matters you have heard in the past. With that said, I'll turn the matter over to you, Mr. Watkins, for deliberation by the board.
Thank you, Your Honor. All right. Who wants to start off?
I have a question that I guess I don't know if we can ask back, but my concern is if this were a new firm, would there have been any notification or any? In other words, was he within his rights had it been a new firm?
If you want to present that question, of course, if you want to discuss it, you certainly can do that amongst yourself. If you want to present that question to a witness, Mr. Crocker, I'm assuming you'd have to vote to reopen the evidence to hear that from him. And you can certainly do that.
Before we go that route, I mean, just in my recollection of the testimony that was given, it seemed that on a new firm, maybe I'm getting confused now, I thought it said that the new firm, if it was within 30 days, I think Mr. Crocker stated that the 30-day rule didn't apply because it was the reopening of an old firm. Did I recall that correctly?
Yeah,
Your question.
but your question is, well, if it was a new firm, would the 30 days have applied? Is that what I understand the question to be?
Right, right.
I
That's my-
thought I recalled that being the case. I don't know if anybody else recalled that.
Are we allowed to go back into the record and just read what was testified?
You can do that. It may be easier just to vote and recall Mr. Crocker before a court reporter can find
All
out
right.
how easily you could find that, or if he addressed that.
Why don't we just
specific
do that? I think that would be the easiest thing. Do we need to do a roll call vote, or how do you?
Doesn't
no.
have to be a roll call, just you need a motion, a second, and a vote if you want to do that.
Do you want to make the motion?
Make a motion to recall Mr. Crocker to ask that question.
Okay, have
Good.
a motion and have a proper second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Okay.
Voted to reopen the hearing of proof, and Mr. Crocker, if you'll step up back to the witness stand. Mr. Crocker, you're still under oath. And
Sir.
All right, thank you, Mr. Crocker, and the member of the board, Spiceland. I'm sorry, I can't see you. You have a question for Mr. Crocker?
Mr. Crocker, if this had been a new firm application, was Mr. Reno within the 30-day rights? Would there have been any procedure against him?
No.
All right. Another member of the board have a question? Yes, ma'am.
I do. I'm not a CPA, I'm the public member, so I apologize if this is a dumb question, but on the advertisement, if you utilize your name, if you advertise and say Jennifer Brundage, and I was a CPA, but CPA out there, just to see if there's interest in me doing tax services, can that be done based on an individual permit, or do I automatically have to have a firm permit too?
You know, Ms. Brundage, we normally require that you have a firm permit in order to do that because you're advertising to offer accounting services through a firm.
I have one additional question, and I think this is key to this whole thing, is was it a new firm or not? And if you look at the rules and the same section talking about notification of firm changes, it refers to the 30 days and the formation of a new firm in subparagraph A, but also in subparagraph E of that same section it says dissolution of a firm. And if Mr. Reno filed all the paperwork necessary to terminate his firm permit, I would assume that means he's dissolved his firm. If a firm has been dissolved, how can it continue? I mean, it doesn't exist anymore. And therefore, any permit that he would submit later, seems to me, would have to be for a new firm. I mean, it's confusing. I guess all I'm saying, based on that language, I can see how Mr. Reno would feel very strongly that he was filing a permit for a new firm.
You understand the question, Mr. Crocker?
I think I do, and let me address the dissolution issue, Mr. Stewart. That has normally been interpreted, at least from management's perspective, to mean dissolution of a partnership, a corporation. Normally, when you have a sole proprietor, it's simply a closure and not a dissolution.
That's not what the language says. It says the dissolution of the firm. Did he dissolve his firm?
That's something for this board to interpret, Mr. Stewart. We consider it a closure.
Robert. Mr. Hall's got a question.
I got a question. What do you do with other firms that file these applications late? Is he the only person in 2013 that filed an application late?
He's the only person that we caught filing an application late. In other cases, we have not had anybody indicating that there is a firm out there that we don't have an application for. I mean, we're talking unlicensed practice, Mr. Haas, and yes, we do have cases like that.
So these things happen, we just don't know about them.
In many cases, yes, sir.
So if Mr. Phillips hadn't have seen this advertisement and filed a complaint, you would have never known about it.
That's exactly right.
Crocker, I have one and maybe a follow-up. Just Mr. Stewart's point, you had just said that with respect to dissolution of firms, it applies to entities and not sole proprietorships. Is that right?
That's the way it's been interpreted from management's viewpoint, yes,
okay.
sir.
So Okay, so we're treating the sole proprietorships differently than we're treating every other entity that conducts public accounting under that interpretation?
Not necessarily, because a corporation can close their license without dissolving the corporation.
Questions? Joseph, any questions of the witness? Mr. Reno, any questions? Mr. Crocker, you can take your seat back then, and so we'll close the proof again and turn the matter back over to the board. Before we do, let me read a charge on statutory construction. I think that's become pertinent. You are the exclusive judges of the facts in this case. You're also the exclusive judges of the law, specifically your statutes and regulations and their application in this case. You should apply the law to the facts in deciding case under these directions. The state has charged the respondent with certain violation of your statutes and your rules. For each of these charges, you must reach a determination of whether the state has proven that the respondent violated these rules, and in your finding of fact, give the underlying facts to support that decision. In reaching a decision of innocence or guilt by the respondent, it may be necessary for you to interpret your statutes and your rules. When the language of a statute or rule is plain, then you must follow the plain meaning of that statute. However, the language is ambiguous, you may give your interpretation of that language so as to explain your conclusion you reach as to the violation charged. If in your deliberations, well, I'm sorry, I'll stop there. That's my charge concerning statutory interpretation. I apologize. I'll turn the matter back over to you, Mr. Watkins.
Thank you. I guess my concern here is that we clearly have some issues with our rules and regs and how we're interpreting, and it doesn't seem quite right to me that we would be in a position to judge this in light of the fact that we don't have a form for renewal, even though we're talking about a renewal of a firm. The language is 30 days. It's not 30 days. It just seems like we're stepping a little overboard on this, I think, in trying to come to some sort of punishment because of a misinterpretation of the rules. You'd hate to think that you'd have to have an attorney to interpret our rules in order to do business, and that concerns me greatly. So those are my comments. I don't know if anybody else wants to share something or discuss.
It concerns me greatly that we don't have a renewal form, and instead, even in this charge, it says that he sent an initial form. So there was no renewal, and that I believe Mr. Reno truly felt he was starting a new firm. He had sold the other, closed it, dissolved it, and if that were the case, we just heard from Mr. Crocker that there would have been no process at all.
I'll just add that I don't see any threat to the public out of what occurred either.
I agree.
I would agree. Further add that the State Board would have not found out about this matter had not the prior employer filed the complaint or brought it to the attention, and that seems to me to be an act of reprisal to a former employee.
Also, is there in this hearing, can we follow up and come up with a renewal form, or is that?
I think we can do that outside of the context of this case.
I don't want to involve myself in the board's deliberations, but if you find that the state has not proven that this is an action that should be disciplined by Mr. Reno, then a simple motion to dismiss the matter is sufficient. You don't have to find facts, conclusions of law, and so forth. Unless you want to draw that order, Mr.
Well, Your Honor, the only thing, I have no problem with that if that's the board's pleasure. I just would like, per, I think, Tennessee Code annotated 5314, in defining an initial and final order, that it has to have findings of fact. I don't have a problem trying to come up with some different findings of fact if the board wants to dismiss the matter.
And I think that goes to how the board wants to address it. I can tell you that boards routinely make rulings, and I say that we sit with 80-some-odd professional boards, that the state's not shown by preponderance of the evidence and the matter's dismissed, and that's the end of it. I certainly understand what the statute says. If the board wants to fashion something in the order here to deal with the issue or to have something on record, you may want to go the next step. But as Mr. Watkins said, you can deal with these issues that appear to be here outside the contested case also.
Any other discussion? I will entertain a motion if somebody would like to make one.
Motion to dismiss.
I have a motion to dismiss on the floor.
Second.
Vote second.
I have a proper second. Any other discussion? All right, hearing none. Do I need to do a roll call on this? No. All those in favor of dismissal signify by saying aye. Aye. Any noes? Hearing none, the ayes have it.
Thank you, Mr. White. Mr. Joseph, I apologize. I have to stop and think. I'm going to call you Mr. Jesse one of these days. I know that's happened before. But Mr. Joseph, can you draw just a short order of dismissal based on that? Absolutely. And submit that to the board. So this matter will be concluded. Any further action, Mr. Joseph?
No, we don't have anything else, Your Honor. Thank you.
All right. Anything else, Mr. Reno? All right. So that'll conclude our contested case matter, and that'll be submitted to Mr. Watkins for signature. You normally sign the order. Just reflect that it was a unanimous vote by the board to dismiss the matter. And members of the board, thank you. You've obviously, or at least there appears to be some discrepancy in your rules, and that's part of what these hearings do, to give you an opportunity to make that fix if necessary. Thank you all.
Thank you. I want to take a quick 5-minute break, and then we'll get back and try to knock out the agenda. Adopt Robert's Rules of Order to conduct these meetings.
So moved.
Second.
I have a. It's okay. I have a motion. I have a second. Any discussion? Hearing none. All those in favor signify by saying aye.
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 Passes. Mark, do you want to go ahead and start with your executive director's report?
Thank you, Mr. Chairman. You have a copy of the Executive Director's Report on your iPad. This was sent to you previously, so if you have any questions about it, I'll entertain those. Let me just make another couple of additions to this. Pursuant to the board's request pertaining to out-of-state travel, I did mention in here the State Board Committee meeting and the Executive Directors Committee meeting that we'll be attending, and the Board of Directors meeting that I'll be attending for NASBA in April in San Juan. I'm also scheduled to go to Miami next week for the NASBA AICPA Summit meeting. That is I'll leave on Tuesday. The meeting's on Wednesday. I'll fly back on Thursday. And then I'm scheduled to go to Baltimore for a quarterly business review meeting on February the 11th. Now, those with the meetings I've already mentioned comprise my out-of-state travel for the quarter board meeting. I also received notification from NASBA that they are relocating one of our testing centers, Prometric.
Hey, Mark, I think Bill wanted to ask a question.
Sure.
Regarding the out-of-state travel, the information is very helpful. I would question the visiting San Juan for the board meeting as an observer. Practice in the past, not only here but elsewhere, is that travel outside the continental United States is not generally endorsed. And that was applied to Hawaii, and Puerto Rico isn't even a state, so.
True, Bill, but one of the responsibilities of this position as chairman of this committee is to attend the board meetings. Don't when I agreed to accept it, that was,
Well, I don't know what the pleasure of the board is, but I object to that trip.
yes, sir, duly
You don't
noted.
need to be at every board meeting, even though you're chairman. You didn't go to the one in Hawaii.
I had the previous chairman fill in for me there. Does the board wish to discuss that?
How does the rest of the board, does anybody have any other comments on that matter? No.
And I certainly don't want to apply for a trip permit that the board is not willing to support.
Mr. Blofeld is right in that requests for travel outside of the continental U.S. and this board have had a bad history in the past. I don't know if the administration's positions has changed, but
I don't know, Mr. Alexander, but, you know, I can apply, and if they deny it, then it's denied. But I can't apply unless the board is supporting.
observation.
Just, it seems to me we agreed to support Mark in taking this position. And we had debate and discussion and all that back then, but I don't see how you serve as chairman of something if you can't be there. I mean, you need to lead the effort, lead the committee, lead the patient. I think we need to support Mark's attempt.
Question, clarification maybe. You're going as an invited guest because you're the chair of...
I am the liaison for the Executive Directors Committee. Yes, sir. I am not a voting member of the board.
I think while I would, you done? I'm sorry. Well, I probably would have chosen a different venue. That wasn't our decision. And as Casey said, we have, agreed to support Mark in this position. I think it would probably look bad to say, well, I can't go because my board didn't allow me. Can you cover for me? Just, whoever the vice chairman or whoever would cover for you. So, I would criticize the choice made. The choice wasn't made by us or Mr. Crocker. So I would think we need to support him in this. Maybe complain to whoever set the board location to a less costly place, but it is what it is.
And I would like to echo your sentiments too, Mr. Eldridge. I agree with that.
Would it be appropriate for us to write a letter to NESBA and complain about these locations?
I don't think that would be inappropriate.
At least not necessarily complain, just say,
To foster better participation,
That's right.
we feel like inside the continental U.S. is easier to sell than
certainly
outside.
Maybe some mention that there have been difficulties before with this board and
Right.
outside CONUS travel. Just, not to go into the gory details, but just a mention of that to be considered during deliberation for future places.
I think NASB was already aware it's cost us 2 executive directors. They hired one of them.
Thank you, Mr. Alexander. I appreciate that sentiment.
See if Channel 5 picks up on it.
Yeah. Is there any further conversation? Bill, do you want to make any kind of formal?
No, I stay in my position.
Okay.
I respect considerations by my fellow board members.
Okay. All right, you can continue, Mr. Crocker.
Okay, thank you. I received a notification last week that one of the locations of the prometric testing centers for the CPA exam is being relocated. It's one that's here in Nashville. They're relocating the 230 Great Circle Road, Suite 229, to 1410 Donaldson Pike, Suite A11, here in Nashville. That test center will go live on April the 4th, 2014. The test center will be down for 4 days so that they can make that transition. The candidates have been notified so that they can make the appropriate provision in their testing requirements. And we are getting 6 additional testing locations with this move, to 6 additional testing seats. I want you all to be aware of that.
Mark, is there another testing center in Nashville? other than the one that's going to be closed during that time period?
You know, Charlene, I don't think there is. I think this is the only one in Nashville.
Closed.
4 days, March 31st through April the 3rd.
Okay.
Unless there are other questions, Mr. Chairman, that concludes my report.
Any other questions for Mr. Crocker? All right, let's move on down to the NASBA committee reports. Jennifer, do you want to talk about the Board Effectiveness Legislative Support Committee?
Yes, actually, there's been a name change. The committee now is called Legislative Support Committee, and the charge, there's a new charge for 2014, and it's to assist the NASBA Director of Legislative and Government Affairs with the development of legislative strategies to enhance the effectiveness of boards of accountancy and develop a network to assist in carrying out legislative strategies. We're going to be having a meeting here in Nashville in March, which we will be getting on to this new business. We had a telephone conference call that I participated in last Friday, and basically we talked about this new charge, the new name, and talked about and approved the report of last year's committee. And just to update you kind of what happened last year the committee and the Director of Legislative and Government Affairs with NASBA set up and implemented a bill tracking service. And that service identifies and tracks at the state and at the federal level bills that are introduced that affect directly or have the potential to impact the accounting profession. The committee started working on a system for alerting boards of that important information, and that's still ongoing, how to do that, and trying to provide a network where boards can collaborate and have discussions. If they know that something happened down in Georgia last year and now Tennessee is experiencing it, then you can start a dialogue about what was effective, what wasn't effective. Out of the committee, they formed a state society relations committee to foster greater dialogue between state boards and societies, and I believe Brad Floyd is on that committee. And then last year started discussion on how to develop a legislative affairs network, that's kind of, I think, going to be a big focus this year, and that's basically identifying people that have relationships with various legislators across the country, so that when there are emergency things that come up, you can actually start a campaign and a dialogue. Some information that was interesting to me, at the end of January, there are 40 states that have sessions that are going to be ongoing, and that as of last Friday, through this bill tracking system, NASBA was actively monitoring 163 pieces of legislation that they identified as having direct impact on the profession, or if language was tweaked, could have impact. They're working with several boards and societies that have requested NASBA's help, such as Alabama, Georgia, Mississippi, Virgin Islands, Puerto Rico, and Guam, about different legislation. And then, as you noted probably in Mark's executive director report, that Wisconsin was really interesting. What happened was, I think Mr. Johnson, the director at NASBA for this legislative and government affairs, was on vacation, and the tracking system that is set up alerted that this bill had been filed in Wisconsin to do away with the education requirement to sit for the CPA exam. So basically, I could go sit for the CPA exam if I so chose in Wisconsin. And I believe, if I heard correct, it was actually introduced by a CPA member of their General Assembly. And within 2 weeks, it had gone through the whole process and it had been passed. So now, NASBA got in touch with AICPA and all these other organizations, and nobody really heard about it till the very end. But because of that quick 2-week process, when they heard about it, it was already kind of through the system. So now they're going back through and trying to, or they got legislation introduced to try to, back that up and change what happened. So I think through that lesson, they've learned that it's communication and everybody kind of tracking and sharing knowledge and information is important, and it's important to stay on top of it and do it quickly, because like in that 2-week lesson, nobody ever would have thought that would have happened so quickly. So now they're having weekly conference calls, NASBA and the AICPA and Accountants Coalition and other groups, just so that everybody stays informed. So that's basically what's going on. Oh, and just so that you know, if you want to go to NASBA's website, you can go to legislative tracking, and there's a state, and you can push on or click on Tennessee, and it'll show the bills that are being tracked.
Okay. And I guess the society has their own too, right? I mean, see, that just came out, as a matter of fact, in the past week or so, didn't it?
We've had 2 or 3 emails about the legislation going through the legislature this year affecting CPAs.
Thank you, Jennifer. Stephen, do you want to take the Uniform Accountancy Act Committee?
Probably can't.
Is this the, I guess, Mark, we need to go over this proposed letter?
Does
Does that fall under this?
Is that the exposure draft?
It is.
Yeah.
I can get that in the committee part.
Yeah. Oh, in the committee. I see what you're saying.
Mr. Brewer's not here. I don't have an update on the UAA committee.
Okay.
Mr. Watkins, I apologize.
Thank you. Law and Rules Committee, I don't know who wants to take that one. That's Troy as well.
I did it yesterday.
Yeah.
I don't mind
Please.
winging it a little bit today.
Okay.
Basically, the two things we discussed yesterday were we had a discussion on the exposure draft for the UAA regarding revised definitions. I think everybody's got a copy of that on your iPad. Basically, it just adds the SSAE standards in there for attestation engagements. Was the major change on that. I don't think there was any action required. We were just discussing it. That's already been implemented. Is that correct? Or finalized? Or
The NASBA Board of Directors at their January meeting voted to include that in the UAA.
okay. So it's. And then the other issue we had discussion on the exposure draft on the UAA regarding firm mobility guidance. This is still pending, I guess, and we have an opportunity to respond. And I think the committee wanted to bring it to the board's attention to see if we wanted to issue a formal response, which I believe that Mr. Crocker has drafted.
He has, and he's given it to me. I can read this for everyone to hear. And this is not something that was voted on yesterday. I think we were just throwing around the idea and let the board decide how they wanted to respond. This is a letter addressed to Ken Odom, Chair, NASBA UAA Committee. Says, Mr. Odom, the Tennessee State Board of Accountancy appreciates the opportunity to comment on the UAA 7th edition exposure draft on firm mobility. The board considers this matter at its meeting on the 31st of January 2014 and approved this comment. This is not approved. It's just the way it was written up. Tennessee currently allows firm mobility and believes that uniform guidance in the administration and enforcement of firm mobility is prudent and necessary. The primary purpose of any board of accountancy is the protection of the public. The public can best be protected by boards working together to enforce accountancy laws and rules across state lines. The concept of firm mobility is the logical successor to individual mobility if we are to encourage licensees to work in various jurisdictions without the necessity of multiple licenses. While we are aware that some boards oppose the concept of firm mobility, we believe that for those that do have some type of firm mobility in place, that uniform guidance would be beneficial. For these reasons, we support the exposure draft on firm mobility guidance. So this would be a letter from me, I guess, if this board so chooses to send this type of letter. But we are more than happy to have commentary if anyone is against it. Everybody's in agreement?
I think the letter sounds good. I just wondered who wrote it for you.
It wasn't me.
Yeah.
All right, so do we have to officially vote for that, or?
Yes, I would appreciate that.
So all those in favor of the firm mobility letter, I will take a motion to, we just adopted Robert's Rules of Order, and I just completely
So
forgot
moved.
that. Okay. Yeah, do I have a
Seconded.
second? Okay. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, it passes. So Mark, we can That if you want me to sign this before I leave today.
I'll get it written up on proper stationery.
Okay. All right. Stephen, do you want to, are you done? You didn't do licensing yet, have you?
No.
Okay.
Proceed.
Proceed.
We have 4 items in the license, come before the licensing committee. The first was an application from Western CPE for state-specific ethics course approval. They had previously submitted this application at the prior meeting, and we requested additional information. After reviewing additional information they sent in, the committee felt that it was adequate. Management has reviewed it and felt it to be adequate, and the committee voted to recommend approval of this course. If it's okay, I'll just go through all 4 of these, and we can vote on those as a whole, if that's okay with everybody. The second request we had was from the Middle Tennessee chapter of Certified Fraud Examiners for exempt sponsor status. Previously, they had operated under their national entity's NASBA number, and I believe there was a change. NASBA made a change, and they're no longer allowed to operate under the national CPE exemption number. So they're requesting that we recognize them for exempt sponsor status. The next request was, excuse me, from MTAS for clarification that approval for CPE credit includes the CMFO exam. We had previously approved MTAS for CPE credit for their course, but we did not specifically state the CMFO exam. I think all they wanted for that was just to get it in the minutes that it does include the CMFO exam, which the committee agreed that it does. I'm not exactly sure the proper way to respond to that. I don't know if that's adequate enough, or does the board just need to make a statement?
I believe the board just needs to make a statement that MTAS includes the CMFO exam.
Okay, so I'll break that out as a separate item, so we don't need a vote on that, correct?
Yes, sir.
And then the last item we had was a request from Eileen Eli for an extension of the AUD, the BEC, and FAR examination. There should be a copy of her request and all the facts in there. Basically, what had happened, Miss Eli had taken the first 3 parts of the exam, or the 3 parts noted there, and she had passed all 3 of them. And then she went and took the 4th part in July of 2013 and did not pass. During that time, she had a series of events that caused her to cause distraction and affected her test scores, including her father had cancer and had fallen and was injured, and then he soon later passed away. And then during that time, she moved. I think she had a broken toe or broken foot or something of that nature. And then during that time, she took it in October of 2013 and did not pass it. I think she missed passing it by 1 point. After the committee deliberated about it and discussed it and determined that her circumstances did warrant an extension, and we were recommending that the board approve a 1-window extension that would extend to June 30th, 2014. That's all the items that I have. Any questions?
You want to go ahead and make the motions for the necessary motions that we need to make?
Want me to do it? Yeah, I'll be glad to.
Yeah.
I would move that we accept the application of Western CPE for state-specific ethics course. Recommend that we approved exempt sponsor status for the Middle Tennessee chapter of Certified Fraud Examiners, and I move that we request the extension request from Eileen Eli for the 4th part of it. She hasn't passed.
Reg or something?
Reg. Well, let's see. Yeah, reg. grant an extension to June 30th, 2014 for that section of the exam.
I have a motion. Do I have a second on any of these items?
Second.
Okay, I have a second. Any discussion? Hearing none.
I do have a question here.
Okay.
On Ms. Eli's request. I think she's requesting an extension for OD, BEC, and FAR.
Yeah, they were.
Oh, you're right.
They were about to expire.
Those were expired, or were expiring.
You're right. Those extend in hopes that she would pass the fourth part, the regs part.
That's exactly right.
Yes, sir.
Okay.
So if we can clarify.
I will amend my motion to grant request extension for the AUD, BEC, and FAR exam scores to June 30th, 2014.
So we had the motion, we had the second. Well, I guess we need to probably, you want to just?
I'll second the amendment as well.
Okay.
Mr. Chair.
All right, thank you. Any discussion? Hearing none, all those in favor signify by saying aye.
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 Okay, any noes? Hearing none, the ayes have it. You wanna do the- Did you have one more?
Well, yeah, we just need to
That
get in the minutes that statement in there. Do I just make the statement, or how do we proceed with this?
Just make the statement, if you don't mind, Mr. Eldridge.
Okay. Formally enter into the minutes that the request for MTAS for clarification, the request from MTAS, let me think how to best say this. We would include the CMFO exam in MTAS request for CPE credit. Is that adequate?
That should do it.
Thank you.
Thank you.
That's all I have.
All right, Commissioner Giannini's here, so I'm going to go ahead and let him address the board. Welcome.
Good morning, Chairman. Board, how are you all?
Good.
We are going to begin doing this annually, coming before you to discuss your previous year's financials, give you an opportunity to look over how you performed, how much money you took in, what we did with it, to chastise us if you don't like what we did with it, or to praise us if you do like what we did with it. So you all have a copy of this, I believe, on your iPads. Is that correct? You may also have a paper copy, looks similar to this.
It's the budget close. You've
Budget
probably seen
close
it
document.
previously. Mark has paper copies.
Okay.
What are we looking at on our iPad?
I don't believe it's on your iPad. Mark has paper.
He's hanging up the hard copy. Thank you.
Thank you.
I'd like to welcome a new Memphian to the board. Always glad to see a new Memphian to the board, Ms. Spiceland. Glad you're here. I'm going to go through this, and I'm not going to stop at every line, but certainly you can stop me if there's something that interests you want to talk about. And otherwise, I will just kind of go through the big numbers. You all are probably a little more accustomed to looking at these kinds of documents than some of my boards, and you may already have it memorized for that matter. So if you look at the top, this looks at the previous 4 years. In the far right-hand column is fiscal year 12-13. You look at your regular salaries and wages of $412,522 at the top. Total payroll expenditures of $557,574, which is an increase of over the previous 3 years. I would note that reflects a raise that went across the board to all state employees on July 1, and so that's reflected in that. Your travel was $37,998, which was down from the previous 3 years. So kudos to you all for that. Now I'm going to drop all the way down to grand total of your expenditures, which was $787,926. Just slight increase over the previous 3 years. Total expenditures were $1,011,481, again up a little bit over the previous 3 years. Your licensing revenue was 1.117648, which was down a little bit from the previous year. And net revenues of $1,063,439, leaving your prior fiscal year reserve at $765,442. Fiscal year balance $51,959. You adjusted balance was $812,501. Was that even faster than you all expected? So, any questions? All right.
We had a question yesterday on the, Casey, you brought it up, we were looking at the budget. Did you want to ask Mr. Giannini about those, or did we just decide that those were a one-time true-up?
I mean, I'm happy with where we got to yesterday,
Right.
but it was on the, I guess, state regulatory fee down near the bottom of the page where, it was 56,200 in 2010 and went up to 57,755 and 59,050, and then it jumps way up to 86,000. But when we were looking at the budget for the coming year, it had come back down. So I guess there's something that's an aberration just in 2013 there.
There is, and I'll think my trusty accountant here can explain that for you. Kimberly Whaley.
Hi, board members. The comptroller performed an audit of regulatory boards during the past fiscal year and found that they wanted us to make a change to the way in which we calculated the state regulatory fee, and that is the change. And that change will be permanent as far as the way the calculation is. Previously, it's been on your active licensees. The new calculation requires that we charge $5 for every 1-year license and $10 for every 2-year licenses that are issued and renewed. So that's a change. Mostly your inactive licensees, because they do technically renew, are counted. So that's the short version. So if you have any additional questions, over the course of time, I'll be happy to answer. You can filter those through Mark if you like.
That help?
Oh, yeah, we're good.
All right. You had a total number of licenses last year of 12,088. And something else I did want to point out on this that I blew past, I apologize. We have started taking your case and complaint revenue and pulling that out. Historically, reg boards had not done that. If you'll notice down below total expenditures, you've got licensing revenue, and you've got case and complaint revenue. If you look to the far right-hand side, you see $31,857. That was your case and complaint revenue from actions of the board. And we're going to continue to do that so that you can see that number. I think that's helpful for you. So I want to tell you, too, about a couple of other things that we're doing. We've implemented a Notify system, which I think you all have all signed up for. Is that right? Scaring me, guys. Come on.
Yes.
You have not? All right. Well, we are going to make sure Director Crocker gets that information to you very early next week, if not sometime today, where you can begin to be notified electronically of anything pertaining to your board, anything pertaining to that we feel like is important for you to know from reg boards. It will be an automatic notification. It would be anything from legislation on down. So I encourage you all to get signed up for that. It's one of the ways that we're going to try to logically. We also are implementing a new licensing system, which we hope to have operational by the end of the year. All of the programs and reg boards have participated in the development of that new program or new licensing system. We've actually determined how much you all are going to pay for it, which I know will be of significant interest to you. And the cost to the accountancy program looks like it's going to be about $70,000 for a new licensing system. We're spreading that cost over all of the regulatory programs in the division based on the number of licensees. That was the most fair, equitable method we could determine to do so. And we believe that it'll substantially improve the interaction with licensees, with the public. We're going to move to much more electronic transactions rather than paper, which we've historically done. Interactions and try to.
Hey, how many years do we have to pay for that?
We were actually, another great thing, I'm glad you brought that up, we are going to be able to pay for it in 1 year. And
How about us? How long do we have to pay for it? That's the question.
Same as cash.
we were under the, we had the understanding historically that we could not use your reserve money for things of this nature. Through working with F&A, we were able to discover that actually for something like this, that's a significant improvement that we can. We thought we were going to have to use current licensing revenue each year. For your program, that would not necessarily be a problem, but for some of my programs, it would have been potentially a significant problem to have to pay for that with current licensing revenue. So basically, it's going to be paid for cash with money already in the bank.
So it's the number of licensees, not the size of their reserve account.
Correct.
For the allocation, right?
Correct. So, based on a consumption basis is kind of where we went. So, you had something else?
No, I wanted to make sure they understood that it is coming out of your reserve balance.
Yes,
as
yes.
opposed
And
to your
we
current
are
licensing
very,
revenue.
very, very grateful that.
Do you have any kind of estimate of what kind of cost that's going to be? To our board?
Yeah, it's about $70,000.
Oh, 70 to us?
Yes.
Oh.
Yeah,
I thought that was for everybody.
Yeah,
I'm
it's
sorry.
about two.
Oh.
It's about.
When's the last time you did an IT upgrade?
It's not QuickBooks.
Yeah, exactly.
It's about $2.5 million is the system that we're buying. We definitely got our money's worth out of the old system. It was bought under an amendment order in 1993, and so I tell you, if most of you were still using your cell phone from 1993, you'd be aggravated most of the time. It is it's going to be entirely different experience internally and externally for anybody doing business with the division, and hopefully it's going to. While I'm here, you guys got any other questions?
Any other questions? No, we appreciate you coming and bringing these things to our attention. And
Sure.
it's always good to see you here and let everybody here know who you are and what you do. And
Always good to be here.
I guess I do have one question. It's non-financial related. And we had talked about these performance plans and all this stuff. When does that process occur?
We have just completed the latest, greatest performance plan for all of my directors, and I will get a copy of that out to you.
Okay.
As we've done in previous years, it is absolutely consistent with all of the other directors. And again, you all certainly have the right and opportunity to make changes on your timeline as you choose. I think that it's helpful that you have allowed us to use the template that we are using for other directors in the division. So we'll get that out to you today. It has just very recently been approved within the last week.
Okay.
Of the food chain.
Questions? We appreciate your time, Commissioner. Thank you for coming by.
Be careful going home and have a great weekend.
Thank you, you too. All right, well, I guess we'll move into the executive committee report. You were done with it. Licensing was done, right, Stephen?
Yes.
Okay. We discussed quite a few things yesterday in executive committee. Yes.
Before we go any farther, there was one more item on the Law and Rules Committee.
Oh,
And that was
okay.
the draft military legislation that we need to look at. Mr. Whitaker, if you will address that for us.
Sure. Just real briefly, as I mentioned to the Law and Rules Committee yesterday, statute was passed in the 2013 legislative session requiring all regulatory programs to promulgate rules and procedures for the expedited licensure of military folks who are involved with professional licenses, and all of the programs are having to do this, not just accountancy. And so in working with my supervisor, Mr. Driver, came up with some draft rule language that is on your iPads. And it's, pretty straightforward, just goes down the line. The first subsection lists that it's a CPA license we're discussing here, since firm permits are not typically individually based. So unless the board feels differently and wishes to say CPA license or firm permit, in the event of, one-man shows, the board could ask to include that as well, and I'd be happy to add it. But other than that, this is language that has already been approved to set forth some requirements for essentially a category of temporary permit that, if based on someone's deployment in the military or coming back from a deployment, could allow them to either get renewed for part of a license cycle to get them to the next one, so that they could renew in accordance with the normal procedures required of all licensees. So after reviewing with the committee yesterday, they did vote to approve the language and to recommend to the board a grant of authority to include this in the next rulemaking hearing, whenever that can be made to happen, along with the prior rule language that has been approved relative to disciplinary penalty CPE hours that has already been approved. So with that, I'll be happy to entertain any questions from the board and go from there.
Okay. We need a motion to accept the language.
So move.
Okay, we have a motion. Do we have a second?
Second.
Okay, we have a second. Any discussion? Hearing none. All those in favor of the motion, please signify by saying aye.
Aye.
Aye. Any noes? Hearing none, the ayes have it. So,
And Mr. Watkins, that does include the board's permission to include this in the next rulemaking hearing, correct?
correct.
Thank you.
All right. Next on the agenda, the executive committee. So we went through several things yesterday. We reviewed the financial information and the travel expenditures of staff, and kind of went through those. And the other thing we went through, and it should be in your on your iPad, is the FY15 budget. The executive committee reviewed that and recommended approval by the board for the budget for 15.
I would suggest, just based upon Mr. Gini's comments, that
We adjust the
we need to adjust the reserve.
for that 70,000.
Yeah.
I thought Mr. Giannini was saying they were going to treat that like a prior period adjustment. They were just going to take it out of the equity balance and not put it in the revenue statement as a correct?
That is
So,
my understanding.
That being the case, well, I guess you could still adjust the budget
You'd have to
down the
adjust
bottom to
Yeah.
show that coming out of the reserve fund or whatever, but the operating budget would not need to be adjusted, okay?
If y'all would take a minute, if you want to look at that, or if you've already reviewed it, and then I'll entertain a motion to accept the budget with that one change that Mr. Blofeld suggested.
And we discussed yesterday that the committee would get more information regarding the peer review oversight.
I was going to talk about that.
Okay.
I would move to accept the fiscal 2015 budget with the one change to add in the $70,000 for the purchase of, our allocation of the purchase of the application system or licensing system.
Second.
Motion, have a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the budget is approved with the amended number. Additionally, we got into, in the budget discussion, the peer review oversight committee, and we have language which I think we concluded at the executive committee yesterday, and y'all speak up if I'm speaking for or speaking incorrectly, that may be somewhat outdated because it was written at a time when we actually operated the peer review program, and the way the society manages things now, we're talking about appointing 3 people and having a budget of 25 to, Mark, correct me, the amounts, 25,000 thereabouts.
About 30.
About 30,000 for this peer review oversight committee to basically oversee, I guess, what the society already manages. And so I think what we were thinking is that some of these rules may need to be revisited, and we may need to come up with a better solution from our perspective as to do we really want to spend that kind of money, or do we want to maybe work with the society, maybe be a little bit more involved with their program and have more or less a representative that would then come back and report to this board? Can we accomplish the same goals that we were attempting to do without incurring all that cost just to have someone re-review what has already been reviewed? So this is a topic of just conversation for the board, so any commentary would be appreciated.
Yes, I'll speak up here. I would like to see us explore other options, and I'm not sure what all those are. I guess I would charge maybe Mark and the staff with thinking about this, trying to formulate some other possibilities. But I mean, I could see where we might want either a member of our board involved directly with the peer review committee and at the TSCPA. I just know they spend a lot of money. They've got a peer review consultant that is really, really very good. I mean, and they pay well for it, and there's no need for us to duplicate those costs over here. But I guess just to keep this board informed about what is going on with peer review, how is it operating, or what are the current problems, things. There's got to be a better way than us going out and hiring 3 people as consultants to do this. I just think that's outdated, and at least we ought to look at it. I may be wrong, but see if there's a better way.
I think we discussed yesterday that management would take a look at it and report back to us at the next meeting.
And I would assume in that language, I can't remember specifically the language, that we have the right to designate somebody, something, some organization to do that on our behalf. I don't know that for a fact, but anyways, if staff could come up with some recommendations on that, that would be extremely helpful. Okay, and then, so is everybody good with that? Okay. We had several requests for endorsements for NASBA vice chair. We talked about those yesterday, and we traditionally do not endorse in these things, and Casey had a very valid point. I mean, none of us know who these people are, so it becomes very hard to endorse. Our group had recommended to the board that we not endorse in these unless somebody has some major objection. I think their letters are actually on your iPad. So is everybody good with not endorsing? We haven't done that in the past, so that would be unusual for us to do that. We also reviewed a request from Jeff Shepard, CPA, PLLC, for a name change. I may let Mark walk you through some of this. In effect, what's happened is this gentleman specializes in doing business primarily with churches, and he wants to change the name of his firm to the, now I don't have it in front of me, what is it, the Church
and
Group?
religious. Yeah.
Church Audit. What Steve said. Stephen said.
Church Audit and Financial Solutions.
Now,
LLC.
what was interesting about all this is that they submitted prior examples of very similar name changes. And so we had a discussion there, but we thought it would be a valid discussion at the board level so that everybody's kind of aware of what this thing is, what they're attempting to do, and whether or not we like it or don't like it. But it certainly seems like there's some precedent for allowing them to do what they're doing, but I don't want to influence you. I'll let Mark you want to add to that, Mark?
Well, I'm bringing it to you because just in my gut, it felt wrong. and I wasn't going to approve the name without the board's input.
Right. So in effect, they're changing their name to more or less align with the type of work they're doing. So it's more of a, I guess, called a marketing issue. But if you look in their letter on your iPad, they do provide some very specific examples that seem to be kind of in line with what they're attempting to do. But I'll gladly take any commentary on this.
I have a question, I guess. I didn't really like this either, actually, but in looking at it, and I understand that I didn't feel like small business was the same thing as specifically identifying church, but I did see the one that said 4 physicians. And I guess my question is, because it was approved in the past, do we feel like we still want to keep going that direction? Is that?
That is definitely a board consideration. I tend to believe when we make decisions, if we have precedents, we tend to stick with those precedents for fear that it will blow back on us if we choose not to. But, I mean, everything's on the table here, so does anybody have any other commentary?
Kind of waiting for everybody to get this out on the table before I open my mouth. Mr. Chairman, I've got some strong reservations about this whole this individual and what he's doing here. If I think, Mr. Crocker, let me make sure this is correct. It's my understanding that Mr. Shepard has been employed by a non-CPA. Do our records indicate that, or do we have records to indicate what his employment's been?
I believe that's correct, Mr. Hoss.
Okay.
Yes.
Mr. Shepard, for some time, and I'm not sure how long, has been employed by a non-CPA in the Chattanooga area. That this particular individual has operated an accounting firm. I'm not sure he calls it an accounting firm, a bookkeeping service or something, but he has for a number of years specialized in churches or the related organizations. A few months ago, there was a very large article in the business section of our newspaper about a training center that he had invested a substantial amount of money in and was developing, or had developed, and in Chattanooga, and that he was going to use that as a area where people would come into and receive training, and I believe at the same time they would receive counseling on financial matters, and investment matters, and those kinds of things. So it just seems to me that there is a relationship here that needs to be investigated, and the use of this term, church audits and financial solutions. I feel like this non-CPA in some way has some influence here that's not really in the best interest of the Tennessee State Board of Accountancy. Now, I'd like to point out to you that in the gentleman's biography, he indicates that he has over 20 years of experience, but then he goes on to say he has substantial accounting and auditing experience working with firms in both Georgia and Tennessee. And at least 75% of his practice consists of representation of churches and religious organizations. Well, Mr. Shepard's practice was only registered this past fall. So what was he doing prior to the fall? If he's been employed by a non-CPA, what was he doing prior to the time he registered his firm? This whole thing really creates an issue for me that is very bothersome.
And forgive me, because you did make the point yesterday that you would like to receive further information on this deal, and I forgot all about that.
I would really like to ask the board to investigate this much closer and see what the real situation is, and perhaps ask Mr. Shepard to come to our May meeting or next board meeting we have and explain himself as to what he's really doing here.
Okay. Does
give us
anybody
a chance
dis-
to ask questions.
Yeah. Does anybody disagree with that? Okay. So we'll just table that for next meeting, Mark. I guess y'all will do some more digging and then perhaps reach out and invite him to attend our next meeting.
Yes, sir. We will do that.
Okay. Thank you, Henry. Sorry.
I'd just like to just mention that a little bit of knowledge that I have about the non-CPA. He doesn't have the best record in the country. And I think this board has from time to time investigated his activities. I'm not sure exactly what all that been found, but I think he's been investigated before.
Was it, I mean, do we have the name of whoever that person is to see if we've investigated them in the past?
I believe it's in Mr. Shepherd's record, yes. So we have the name.
I think that'd be helpful to know. I mean, if he has, and if we get an opportunity to ask questions of Mr. Shepherd, I'd like to know if there is a relationship, and if there is a relationship, whether or not we've had issues with this person in the past.
Find that out for you.
Mr. Chairman, may I ask for clarification? Is this something that the board is saying, okay, Mark, go get additional information and bring it back to us and they can come if they want to? Or is it more along the lines of, Mark's going to keep digging, but this is sort of, I don't want to say conditioned or a contingent, like if you don't come and explain yourself
Henry, how
to
do you
us-
feel about that? Is it an opportunity for him to come, or are you wanting him to appear before this board?
I'd like to put out an opportunity for him to come, because if he fails to explain himself in this, then I would encourage the board to vote against this.
Okay. Is that clear?
Yes, sir.
Okay. All right, and then the other thing we discussed was on a firm acquisition, and it involves DeCosimo, and they acquired another firm. They established a new, Mark, help me through this. What did they do? They did the LLC at the top, right?
DeCosmo Hyde LLC is a single-membered LLC owned by Joseph DeCosmo and Company, PLLC.
Okay.
And Mr. DeCosmo is the sole owner of Joseph DeCosmo, PLLC.
Okay. So there was some, I think basically where we ended up in executive committees that we did not end up seeing a problem with it. I think Mr. Stewart found in the rules that it seemed to be okay with how they were structured. We had some discussion, but then I think even further, Mr. Stewart said earlier that they had even checked off the box on their application that they were tax only.
Yes.
And so there was no peer review issues, so to speak, on that. Because that was one of the concerns I think we talked about yesterday. But in effect, I don't know that we had any, I mean, I think our recommendation is that it was fine, and that we should allow this this structure to be, it's deemed okay in the eyes of the board. So, Mark, do you want to explain it any better than that? Because I just butchered that.
You all have the application in front of you. I think it's pretty self-explanatory. Yeah. It was just a matter of a company owning a company that I wanted to bring to your attention, since this is kind of setting a precedent. We don't have this on record that we can find.
Chairman, is there a reference in our rules or statute related to this type of structure?
What did you read yesterday, Casey?
Well, it's actually from Mark that there's a section of rules dealing with non-licensee owners of CPA firms. But what I think we determined is DeCosimo and Company is a licensee. They're not a non-licensee. Okay. So since they're licensed, there's nothing that we consider that I've seen that prohibits this. I guess the other thing would offer is DeCosimo and Company, I think, is probably the top 50 firms in the country in terms of size. They have offices in Memphis, Chattanooga, Cincinnati, Atlanta, Birmingham. They're a good firm, and I don't think there's any, I think they've just developed a relationship with this CPA that's a very small practice here in Nashville. So I don't think there's anything they're trying to do that's that's wrong here. I think this is just a way, from a business standpoint, they've chosen to structure this arrangement. So I can't see anything wrong with it. So
They appear to be following the model set out by Warren Averett, where
Do what?
Warren Averett out of Alabama.
yeah,
They're acquiring firms and calling it Warren Averett, whatever.
Roberts, if you'll look in TCA section 62-1-108, that's starting firm licensure.
I just found it, yeah. So the ultimate parent, the ultimate owner, satisfies the requirement of ownership then. Is that right? Okay.
Apparently so.
I think the board's position might be different if this PLLC were either not a licensee or there was some question as to the percentage of majority ownership, if it was not 100% a firm or something like that. So the board could well revisit this question in the event of a future application that doesn't appear to fall under the exact same set of circumstances as this one. So just thought that might want to be on the record as well, that this structure as presented appears to be compliant, but not every business or corporate entity having part or full ownership interest is automatically okay just because of the board's decision today on this matter.
I'm not trying to be dense, but could you, just to be clear, so the ultimate parent owner, the DeCosimo company or the group, it satisfies the majority ownership requirement set out in the code?
This one does, because the PLLC that Mark was referring to in the application is, I believe, 100% CPA owned. So if that entity is 100% CPA owned and it's the sole owner of the LLC that's
Right.
applying, then there you go.
Okay, thank you.
We don't need to do anything with that. That's just approve the application and
Right.
move on.
Well,
Okay.
I would like it on record that you all are approving this, if you don't mind voting.
Okay.
Include that in your report.
Okay. I have a
Second.
motion.
Second.
I have a second. Any discussion? Hearing none, all in favor of the motion, please signify by saying aye.
Aye.
Any opposed? Hearing none, the ayes have it. Okay, one last thing I wanted to mention, Mark. This kind of came to my mind after we were talking about all this peer review oversight and all that. When we get these applications and just throughout this application review and all that, they check that they do a test work on the application. Do we in any way, shape, or form track that in a spreadsheet, database, anything like that? In other words, if somebody is doing a test work and they file the application, is there a report? Is there a way to generate those firms for which they filed an application in which they check mark the attest box?
Not with the current system, no.
How can we, I guess my question is how can we start tracking that stuff? Because it seems to me when we have a hearing or we have a case that comes before this board, it's usually because someone turned somebody in, we see something in the newspaper. It seems to be a very reactionary issue. Another state may notify us of a suspended license or revoked license. This would be one opportunity where this board could ensure that those people that select the attest function could make sure that they're enrolled in the peer review program at the state, correct?
Yes.
And right now, we have no mechanism to do that.
Pat is tracking those on an individual basis, but there's no spreadsheet, Trey, and there's no way to pull that out of the RBS system that we're currently using as to which firms.
How many active
perform.
permits do we have, firm permits?
For firms, 2021, I believe.
It wouldn't just be an inordinate task to review those files, would it, and make a list? I mean,
Well, now, the TSCPA provides us with a list of those enrolled in peer review program.
that's not the check. The check would
that's
be
not
from
the-
the other.
Well, what about
Right.
the renewal process, Mark? Are there questions on there? Is there not a question that on the renewal that says, do you still provide these kind of services?
Yes, there is a question on the renewal form, but here again, that is online and automated now. So we don't actually manually touch that paper all the time.
We key those applications into, it goes into the database. Where does it go? You get that piece of paper back, and what happens? Do you fill out some form in a system? I'm trying to get the accounting for those applications down.
The applications or the renewals?
Or the renewals or initial applications.
Okay. If it is a sole proprietorship with no additional CPA employees, they can renew online with no paperwork being sent to us. And that's just an online renewal system. We don't.
Y'all get a printout daily from that, or how do you track that? That's what I'm trying to figure out.
We get a printout daily of those that have renewed.
Okay.
Yes. If you are required to fill out the additional forms, the additional attachments, which most of the firms that are providing test services are, then those have to come to us via fax or via email. And those are checked and scanned into the FileNet system.
Do we have an active list of all the active firm permits that are out there?
I can generate that. I don't have that.
And does that generate in some proprietary software, or can you export that to Excel? Or I'm just trying to get a feel for what the system can and can't do.
I'm not sure that I can export it to anything, Trey. I think I can get a list of the active firms.
Well, and that's what I'm wondering. If we get into this new system, will that fix that problem?
Hopefully, yes. That's one of the things we've asked for.
Okay. I think what's important, and the only reason I'm bringing this up, is all of us here that are in public accounting have to abide by the peer review process. And, I'm not sure right now that the State Society would even know if somebody should be getting a peer review. I mean, there's no check and balance here is what I'm saying. It's a very one-sided deal. I mean, it's kind of like it's, trust but verify kind of thing. You're on your honor to enroll in the system. So I don't know. If you could research some of that for me and just figure out what we can do to provide that list maybe over to the society so that we're ensuring that we do have 100% participation of those that have selected a test on their records.
See what we can do.
Okay. And with that, I'll end the executive committee report. The last report is the probable cause committee. Are you going to go through all that, Chris?
I will be glad to. Mark, did the updated, do they have paper copies? All right. You should have paper copies in front of you of the updated legal report. The draft of the report that was on here that I sent out about a week ahead of time of the board meeting had 12 items on it. There were additional matters where they were concluded. The investigation report was received, so now the paper copies you have in front of you, there are 24 items. Before I get into that, just a couple of things. The legislative review that's later on the agenda, there is no update for this board. I've not been made aware of any dire pending legislation that is going to substantially affect board operations. If that happens, then we'll address it at the time being. I do have such legislation for my other two programs, but not this one. So we don't have to do that later. And
can I ask a question about
Sure.
that? I understood that there was a bill in the legislature brought over from last year that affects the executive director of the state board.
right,
Is
Mark
that not something that should be disclosed to the board?
I mean, I can certainly talk about it. Mark had asked me that very question, and as I understand it, the assembly terms, the 108th Legislative Assembly, that is a 2-year matter, and so this particular bill, which would make certain changes to the executive director's role in reporting, and Mark probably knows more about that than I do, but it was filed in 2013 and did not go anywhere and was not passed in 2013. And I did check the calendar, the legislative calendar, and something called 10 Tracks, which is the bill tracking system that we used earlier this month and then again before the meeting. And there's been no calendar action of any kind from any committee of either house of the legislature on that bill. So the last thing that shows there is from 2013. So while in theory that bill could be brought up again and considered in 2014, it has not so far. And so there's been no subcommittee or committee action taken on it. And until and unless that happens and it gets on a calendar somewhere, it's exceedingly unlikely that it will go anywhere. But then again, as Jennifer mentioned about the Wisconsin educational matter, things can move fast. So, I think the bill filing deadline comes up middle of next month, and so if something comes up and it looks like that's going to be moved on, Mark and I will figure out some way to try and let you guys know about it. But if you don't hear from us about it, you can assume that bill hasn't gone anywhere. If there are no further questions on the legislative report, before I get into my part of the legal report, I'm going to turn this over to Jesse. He has one supplemental matter that is in litigation, but he has a proposed settlement for the board to consider. He's been waiting a while since his formal, and we'd like to get him back on the road.
Thank you. I've got one matter. You all should have received a supplemental legal report on a matter received for formal proceedings. This is a settlement, and this is a matter involving Mr. Pickering. The complaint in this matter, the staff opened it in June of 2012 based on the receipt by the staff of a final judgment of the Knox County Chancery Court. You all have it. I just wanted to make, okay.
Yeah.
All right.
On the iPad.
A final judgment of the Knox County Chancery Court was entered against this respondent in May of 2012 in an action captioned "The Estate of Robert F. Unger versus Stanley H. Pickering." This judgment was $140,824.85. The respondent was found by the Chancery Court to have breached his fiduciary responsibilities as prior executor of the estate. That judgment against him is now final and unappealable. At the time the estate was opened, it did contain sufficient cash to pay all taxes in full. Specifically, without going through all of the findings of fact, and I have provided you all with the detailed findings of fact and the detailed conclusions of law. Specifically, the respondent failed to move with reasonable promptness in filing the federal and Tennessee state estate tax returns for this estate. He submitted 2 insufficient funds checks during his tenure as prior executor. He submitted a $50,000 insufficient fund check to the Tennessee Department of Revenue in June of 2008. He submitted another insufficient funds estate check of $129,000 and a little more than that to the Department of Revenue in December of 2010. He also paid himself an executor's fee that had not been approved by the Chancery Court and without the knowledge of the heirs in the amount of more than $41,000. In sum, he was found to have failed to discharge his obligations in a timely fashion, and his carelessness caused the estate to pay additional penalties and interest to the IRS, as well as to the Tennessee Department of Revenue, and additional attorney's fees. A consent order was issued to the respondent last year through Chris. The respondent did not agree to settle the matter informally then. The recommendation that was presented to the board then and that was approved by the board, incorporated in the prior proposed informal consent order, was that he pay a $5,000 civil penalty and that his CPA and firm permit licenses be placed on 2 years probation. He didn't sign it at that time. After I filed the notice of hearing and charges, and about 2 weeks ago, he did sign the agreed final order, agreeing to pay that same civil penalty in addition to a $200 assessed investigatory and hearing costs amount to reimburse the state for its initial docketing fee in this matter. And I present this to the board for your consideration and hopeful approval as an agreed final order. And I have that proposed agreed final order, and if you have any questions, I'm here to try to answer them.
And Mr. Pickering has paid that $5,200 in full, has he not?
I'm so sorry. That is an important matter. When he signed the agreed final order, he sent in his check for the entirety of the civil penalty and the assessed investigatory and hearing costs, so that has all been paid.
Know if we have cashed the check yet?
Yes, we've received that from the fiscal office. It has been processed.
I'll entertain a motion to accept the order.
So moved.
Motion, I have a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, the ayes have it. Thank you, Mr. Joseph. Yep. Chris, do you want to go ahead and continue?
Sure, I'll be glad to. On the legal report that the board has hard copies of in front of it, the 24 items presented were approved as written by the probable cause committee. Of those 24 matters, I try to group them by the proposed recommendation. Items number 1 through 10 are recommended letters of warning. Those are primarily privilege tax delinquency cases with various fact patterns. Item number 11 is recommendation for a letter of instruction. This is a matter that would normally be handled at the staff level by cease and desist letter in accordance with board policy. However, because this non-licensee is still in the process of making some of the changes needed to come into compliance, the recommendation is for the letter of instruction and to have, I believe it's Mr. Butler, go back out to the premises within a reasonable amount of time for the respondent to make those changes to ensure that that's been done. Items number 12 through 19 are proposed dismissals. Item number 18, the kind of twist on that is for dismissal of the complaint without prejudice because we have not been able to locate the respondent at this time. And so by dismissing it without prejudice, the cause of action, the board may take it up later even if it assigns it a new complaint number. And also there'll be a notation placed in the respondent's licensing file that the license will not be reactivated without specific board approval. Item number 14 we'll discuss in a little bit more detail momentarily, but that was considered by the board at its October meeting. Then on items number 20 through 24, those are proposed consent orders with various degrees of recommendation for disciplinary sanctions. Number 20, the board had previously considered this at its October meeting, and due to the circumstances covered in the summary, financial hardship of the respondent and some pretty severe personal and financial issues, the respondent requested a reduction of the civil penalty from $1,000 to $500, and both Mr. Crocker and myself would have no objection to that if the board approves it. And then number 14 is now a recommended dismissal at the October meeting. There were essentially two sets of issues. Number one, there some conduct by the respondent relative to internal controls at the firm at which he was formerly employed, and then another kind of track of allegations that clients of his, while he was at that firm, were unhappy with his work or that work was substandard or things of that nature. Because it appeared in October that the board was leaning toward dismissal of the employment kind of internal control related part, but the board did ask for Mr. Butler to go obtain some additional information about the allegedly unhappy clients and substandard work. Mr. Butler did do that additional work and was able to conclude that there was insufficient evidence to substantiate the allegations of unhappy clients or bad work. So based on that and the board's prior leanings, the recommendation for number 14 is now dismissal. And with that, I will be happy to entertain any questions on any of these matters.
I assume the committee, everybody was okay on the committee with what was on there, so.
Yesterday at the committee meeting, the 24 cases were reviewed, and the committee concurred with the recommendations in all cases. And on behalf of the committee, I move that the actions recommended by the legal counsel as outlined in the material before you be approved by the board.
I have a motion on the floor. Is there a second?
Second.
Okay, I have a second. Any discussion? Hearing no discussion, all those in favor of accepting the recommendation, please signify by saying aye.
Aye.
Any noes? Hearing none. Chris, you have your approvals.
Thank you, Mr. Chairman. And Mr. Mills might have about 5 minutes worth of statistics to report on.
I hope not.
You have a report in your little iPad. If I can get mine to come on. Shows the status of the current the committee some additional information yesterday. I will hold from the total board until we've had it approved by the committee. Requested some tweaks to the information he received. If you look at page 2, you can tell that our complaints are fairly stable. One thing I wanted to point out is, if you'll notice the 26 cases that are shown as part of legal, you just heard 24 of them. So
Thank you, Mr. Mills. Anybody have any questions?
Chairman, one final matter, just kind of to, since it's a new year, keep the board apprised of where we are. In 2009, when I came to work for the state, the performance measure, the 180 days that has been made reference to before, this board's compliance was at 11%. And the benchmark, as initially stated, was 70%, and it's now been raised to 75%. This board is now, I believe it's above 86% compliance with that performance measure. And, you know, it's to the point now we've made enough progress where if there is even one case that goes past that 180 days, both myself and the investigator assigned to it and Mr. Crocker know what that case is. We know why it's going past the 180 days. And if somebody came to our office and had the report handy and wanted to know why, we could all explain it to them.
We certainly appreciate y'all's hard work on this, because I know it used to be a major problem. So, all right, any old business?
I could say one thing.
Okay.
Mr. Giannini mentioned the notification. That was in my executive director's report in October. It is on our website. Please go on and sign up for that notification. That will get you emails concerning your license.
Take us off a list.
Take me off the list.
Take you off the list, exactly.
Mark, would you send an email out, just a reminder, please?
Don't copy all of us.
Individually.
Send it via Dove or, you know.
Pigeon.
Pigeon, yeah.
All right, any new business? All right, I think with that, we are adjourned.
Very good.
Did this thing ever reach you?
Didn't so bad for a formal.
Whoops.
Me too.